Serial number 40. For 2 weeks time.
मेंशन करके एडजस्टमेंट नहीं होता है, इसलिए सुबह सुबह टाइम वेस्ट मत करो। आप तो ठीक है ना, आपको रिस्पॉन्सिबिलिटी दिया है, केस जब कॉल आउट हो तब आइएगा, हो सकता है नहीं कॉल आउट हो।
Supplementary list of finance for item 1, second appeal 337 of 2018.
इसमें रिस्पोंडेंट नंबर 2 और 3 का टोटल अमाउंट कल ही रिसीव किया है। नेक्स्ट वीक में
Essay number 337 of 2018. Where we counsel for the नाम बताइए अपना।
ओम प्रकाश
Mr. Om Prakash Singh, advocate, submits that he has received wakalatnama on behalf of respondent number
2 and 3.
2 and 3, and he undertakes to file the same by today
Yes, sir.
during the course of the day.
नेक्स्ट वीक में कर दिया।
Post this case on 20th March. 20 March. Record आ गया है?
Item 2, contemptible 864 of 2023.
It is substantially complied, Your Lordship. The grievance of the petitioner was that they want regularization, Your Lordship. That has been approved, Your Lordship. But the file is pending before the Council of Ministers, Your Lordship.
तो पिछली बार भी एक कहानी आप
No,
सुनाई।
Lordship, that time, Your Lordship, after that, Your Lordship, the Department of Personnel made out some defects, Your Lordship. We cured it and we set the file again. That they have approved, Your Lordship. Now the file is pending before the Cabinet, Your Lordship.
कितना टाइम लगेगा?
We are praying for 6 weeks, Your Lordship. By that time, Your Lordship.
कैबिनेट मीटिंग होगा तो आप प्लेस करेंगे ना?
Yes, sir.
और लिखाएंगे इट इज पेंडिंग बिफोर द कैबिनेट।
Indeed, Your Lordship. We have given supplementary counter. Shukla also has mentioned that.
There is
Paragraph number 8, Your Lordship.
proposal will be placed.
Before the council motion,
Will मतलब you said it has already been placed.
पहले प्लेस किया गया था Lordship, but वो वापस आ गया था because certain defects थे Lordship. Defect was that जिन petitioners ने हाई कोर्ट अप्रोच किया है उन्हीं के लिए कंसिडरेशन किया जाएगा Lordship.
However, after the consent and approval of the Department of Personnel and Law, proposal will be placed. अभी तक तो प्लेस हुआ नहीं है ना? Content case 864 of 2023. Counsel for the parties are present. Counsel for the opposite party has submitted that a supplementary show cause has been filed on behalf of the opposite party number 3. Stating that after doing the needful, the matter will be placed before the cabinet and a request for adjournment has been made for 12 weeks.
direction was only to pass the reason order.
पास
Yes,
पास
sir.
कर दिया,
Yes, sir.
रिजेक्ट कर दिया,
No, not sir. They have affirmed it.
इसका क्या मतलब?
इनका रिप्लेशन का क्लेम हम लोग मान लिए
मान लिए तो क्या
That
कर
has
रहे
to be
हैं?
approved by the cabinet.
हाँ तो क्या कर रहे हैं? मान लिए हैं तो he has not seen the result of the order. मान लिए हैं और ठंडा बस्ता में डाल के अपने लॉकर में रख दिए. Is it a compliance of order?
Substantially, lordship.
आपको घर से देना है अपने? नहीं ना. That is his right. And every day is important for him.
Indeed, lordship.
Opposite party number 3 कौन है?
Lordship, the district daily development officer.
Compliance नहीं होगा ना तो कंसर्न मिनिस्टर को नोटिस कर देंगे. समझ में आ रही है बात? Therefore we want you to take active step. ये ऑर्डर के इस ऑर्डर के साथ जो है उसको प्लेस किया जाए.
Indeed.
The director, dairy development director.
ये तो डायरेक्टर है डेयरी का.
Director
Yes,
है
sir.
opposite party.
District.
Considering the supplementary show cause, pose this case on थर्टीन्थ ऑफ जून. हो गया आपका पूरा टाइम कंप्लीट? यस. 13th of June 2025. It is expected that opposite party number 3 shall take active steps so that the matter is placed before the cabinet. The matter is placed before the cabinet, na?
Yes.
Before the cabinet for appropriate orders, and the fact that the present content petition is pending will also be placed before the cabinet. The supplementary show cause be filed by the supplementary show cause annexing the compliance report be filed by 11th of June.
11th of June.
Violation item 5, contempt civil 717 of 2024.
All defects have already been removed, my lord.
Order has not been complied, lordship. So now, if lordship sees lordship first last order, and then I will show lordship how they are acting not to comply the order passed by the lordships. The order dated 3/1/25 lordships. Have a look.
What do you have to say?
Your Lordship, there is a direction in the secretary to file the super regarding
Where is it?
the entitlement. Already filed on 28th of February.
Saying what?
Here seen using as per para 7, Your Lordship, we have already paid fixation of the petition has been done by the department, right? Memo number 398 dated 27 Feb 2025.
So
We have already.
you have done it already. Now who has to take up?
Lordship, lordship still a wrong submission. If lordships comes to page 11 to the super, they have filed. That 27 to 25 after lordship intervention twice, they have sanctioned it 6, 7, 5th, 6, 7. Now the second annexure B, page 13, if lordships say, sees, on they say that they have already released fund in the favor of Kolan University on 29/4/24. Now the next page, what they have says, internal page 2, clause 8 घ स्वीकृति राशि के ऐसे बकाये का भुगतान ना किया जाए जिसमें केंद्रीय की राशि सम्मिलित है. Lordship is aware that the 80% grant was come from the central government and 20% state. They have already received grant for 5th, 6th, 7th, and now they are saying the 80% grant which has been given by the central government should not be given to the petitioner or any other.
No, you are concerned with your quantum only.
Yes, I am entitled for my contempt.
You are only entitled. So where is the
Yes, why I am saying lordship?
पैसा उनके पास कहाँ से आएगा? How are you bothered about it?
100% lordship. Now क्या हो रहा है ना और भी सिमिलर मैटर में इन लोग सो कॉज में यही फाइल कर रहे हैं कि 8 घर से बोला जा रहा है कि सेंट्रल गवर्नमेंट का पैसा जो है वो भी नहीं दिया जाए, तो टोटल पैसा हमको मिलना है, तो सेंट्रल गवर्नमेंट का फंड 80% जो होता है बोलते हैं नहीं देना, तो 20% ही देंगे ये।
तो कैसे क्या दिए हैं आपको?
अभी तक कुछ नहीं दिए।
देने दीजिए ना पहले।
हाँ, क्योंकि हम अदर सो कॉज लेकर आ गए हैं।
क्या मतलब है कि वो आप आम खाने से मतलब है?
हाँ, हमको पैसा मिलने से मतलब है। देखिएगा इसमें भी वही लाइन है, लोग लिख के कोलाल यूनिवर्सिटी की 8 गा मना है देने से।
Entire amount, right? आपका पैसा कहाँ से, आपको पैसा रिलीज हो गया है, सेंट्रल गवर्नमेंट का फंड भी रिलीज हो गया होगा, आई एम श्योर। आया है कि नहीं आया है? नहीं,
100% आ गया, उसी लेटर से क्लियर हो जाता है कि यूनिवर्सिटी को डायरेक्शन है कि 80% सेंट्रल पैसा को नहीं छूने के लिए, तो इनको ग्रांट सेंट्रल गवर्नमेंट का भी मिल गया यूनिवर्सिटी को, डायरेक्शन दिया जा रहा है कोल्हान यूनिवर्सिटी को 8 गा से
भुगतान करने के पूर्व विषय ये आए कि गन्ना की निःशुद्धता जांच कर लें। कौन सा वाला?
इंटरनल पेज हजूर आया जा रहा है
14, रनिंग पेज 14, इंटरनल पेज 2, कौन सा वाला क्लॉज?
हम दिख रहा है पेज 10 इंटरनल पेज 2, नहीं समीर कुमार से
कौन सा क्लॉज है?
लॉर्डशिप 8 इंटरनल पेज 2 क्लॉज 8 घ
पढ़िए।
स्वीकृति राशि
नहीं, ये मैच नहीं कर रहा,
ऐसे बकाया
ये
का
मैच नहीं
भुगतान
कर
ना किया जाए
हाँ।
स्वीकृत राशि से ऐसे बकाया का भुगतान ना किया जाए जिसमें केंद्रांश की राशि सम्मिलित है, द शेयर ऑफ द सेंट्रल गवर्नमेंट। एक हैंड में ये बोल रहे कि हम पैसा पूरा सैंक्शन कर दिए, यूनिवर्सिटी को पे करना है, और अदर आप एक क्लॉज लगा दे रहे कि आप पैसा मत दीजिए।
For the parties are present, the learned counsel for the appellant and the petitioner has referred to the communication dated 29/4/2024 as annexed with the supplementary show cause to submit that as per clause 8 within bracket G, it has been mentioned that the university should not be paying the amount in which the contribution of central government is also involved. The learned counsel has submitted that there is no justification for this clause, and by insertion of such a clause, the legal dues which the petitioner is otherwise entitled has been denied. Counsel for the opposite party state is directed to seek clarification in connection with this, with the submissions which have been made by the learned counsel for the petitioner, and file a supplementary show cause in this connection as to under what circumstances clause 8 within bracket G has been included in letter dated 29/4/2024. Correct?
29.
In the meantime, the learned counsel for the respondent university has submitted that the admissible amount will be immediately released in favor of the petitioner, and they shall file a show cause. Okay? Pose this case on 11th of April. The supplementary show cause on behalf of the state be filed prior to the next date, and the counsel for the university shall also file show cause upon payment of the admissible amount to the petitioner. After payment of the admissible amount, पे करके show cause फाइल करें। अगर पूरा कर दिए तब तो कोई बात ही नहीं है, फिर तो इनका ग्रीवेंस खत्म हो जाएगा। और अगर पूरा नहीं किए तो जितना एडमिसिबल है दे दीजिए, बाकी यही जवाब देंगे कि पूरा क्यों नहीं दे रहे, ठीक है?
From DD list for final disposal item 1, second appeal 157 of 2019.
May please your lordship. My lord, may kindly see me, lord, the order dated 13/2/2025, order number 11, by which, my lord, additional substantial question of law was formulated by the honorable court.
So it was reformulated.
Good lordship, lordship.
It's the same question which has been reformulated, or it is a different question.
Different question.
There are two questions to be
Lordship.
answered. There are
Lordship.
two questions to be answered.
Lordship, lordship.
Where is the respondent? He's absent. Anyways, you are.
Now, lordship, may kindly see, my lord, that this is, my lord, the defendant's second appeal against the judgment of effort.
Your Ladyship, Mr. Sarkil, Mr. Kaushik Sarkil is left before court number 6, Your Lordship. I was praying for 1 to 2 cases, Your Lordship. Passing.
पास ओवर कर दो। जैसे वो फ्री होते हैं उनको बोलिए आए।
Will you please?
ऐसा नहीं हो कि वो आके फिर टाइम मांगे।
No, no, that will.
Are it possible at 2:15?
नहीं 2:15 ऐसे नहीं करना। आने दीजिए उनको, 2 केस के लिए बोले हैं ना।
जी
2 केस यानी 11:30 बजे और
ठीक
तो ये टेंटेटिव यही है ना?
जी।
हाँ 11।
ठीक
Item Q, first appeal 77 of 2023, along with items 3 and 4.
There are 3 appeals. एक 44 है, एक 77, ये दोनों मेरे हैं, और एक है 156 जो रिस्पोंडेंट के हैं। Yes. And all 3, you let me see, are relating to the same land of 5.1 acres belonging to 2 persons who are not there in this world. One Algu Ram and another Jogeshwar Ram. And very surprisingly, 2 orders which are against me, in which I have raised some legal issues, the same legal issues have been answered in my favor in the next order, that is order in 156. तो 156 का आदेश मेरे फेवर में है और उसमें वो सारा चीज कंसीडर किया गया है जो मेरे दो अपील जिस कारण से मैं यहाँ आया हूँ उसमें कंसीडर
Are they
एकदम
arising out of
कॉन्ट्राडिक्टरी।
the?
Yes.
Are they arising out of the same appeal?
No,
Same proceeding.
different, same judge, same
Same
issue,
judge से क्या मतलब है?
Different suits.
नहीं सूट्स 3 हैं क्योंकि जो डिवॉल्व हुआ सक्सीड किया उसमें अलग अलग लोग थे। ये 2 लोग इशूलेस मरे, अलगू राम और जोगेश्वर राम, ये 2 लोग इशूलेस मरे। तो जो लैंड डिवॉल्व हुआ वो अलग अलग लोगों के नाम पे और उन लोगों ने बेचा। तो 3 सूट फाइल हुए, 3 सूट में 2 सूट मेरे अगेंस्ट गए और 1 सूट इनके अगेंस्ट गए और ये दोनों जो ऑर्डर्स है बिल्कुल कॉन्ट्राडिक्टरी है। दैट इज द इशू बिफोर योर लेडीज।
That is the issue, मतलब क्यों नहीं सब क्लब कराए?
क्लब नहीं हुआ,
सूट क्लब क्यों नहीं हुआ? क्लब हुआ था।
क्लब हुआ जस्ट फ्यू सेकंड्स।
Contradictory orders लेके आ गए हैं, सूट क्यों नहीं क्लब हुआ? Are the suits arising out of? They were not club.
It has been held by the learned court before that
first two of them, what is the fact? In the first two cases, the person who has given power of attorney are not the family member or connected anyway to these two deceased about whom my learned colleague is saying. And the third one is saying that they are third person who has given power of attorney in third suit, which is against me. The person who has given power of attorney is the relative of the
देखिए
deceased.
ऐसा है ना कि ये 3 सूट से अराइज कर
Correct.
फैक्ट्स आर क्वाइट कॉम्प्लिकेटेड आप अपना रिटन नोट्स नहीं बनाएंगे तो कैसे होगा कम से कम फैक्ट पे तो आप लोग को रिटन नोट्स बनाना ही पड़ेगा ना
Fact
ये
पे-
3 या तो बोलिए हम एक सूट डिसाइड करते हैं सबसे पहले ठीक है ऐसा तो होगा नहीं तो
Yes.
आपको अपना फाउंडेशनल फैक्ट का रिटन नोट सबको मिला के बनाना पड़ेगा ना
इश्यू एक बहुत कॉमन इश्यू है.
आपकी तरह इंटेलिजेंट हम नहीं हैं
हम बस अपनी बात थोड़ा एक बात खाली बोल रहे हैं.
देखिए ऐसे बात करने से कोई फायदा नहीं है
नहीं।
इट विल वेस्ट द कोर्ट्स टाइम
हुआ ये कि
क्योंकि आज तो डिसाइड नहीं हो पाएगा क्योंकि नाउ एक नॉर्मली कब क्लब होता है व्हेन दे आर अराइजिंग आउट ऑफ द सेम प्रोसीडिंग्स अब 3 प्रोसीडिंग्स का सूट विद रिस्पेक्ट टू द सेम प्रॉपर्टी आपने क्लब कर दिया तो हम क्या कहाँ से क्या हम लेके
with
जाएं
respect to 3 cell deeds,
देखिए आप बिना समझे बहस कर सकते हैं हम बिना समझे जजमेंट नहीं लिख सकते है नहीं
Milord, this before other bench, the matter proceeded as it is without clubbing. So I think it is better to club, and we'll come prepared with our notes.
आप भी बनाइए भाई
Yes.
नोट्स फाउंडेशनल फैक्ट
Any
बनाइए
one
जिनोलॉजी
hearing will be
बनाइए
finished.
और सब में पार्टी अलग अलग है कि पार्टी भी सेम
पार्टी अलग है. पार्टी अलग है. वन पार्ट कुछ सेम है कुछ अलग है. कुछ पार्टी सेम है. Plaintiffs are same.
इन ऑल द केसेस प्लेंटिफ्स आर द
In
सेम
all the cases,
Plaintiffs are the same.
plaintiffs are the same.
Plaintiffs are the same.
Defendants are different.
And I am the purchaser in all.
इन ऑल द केसेस प्लेंटिफ्स आर सेम
Plaintiffs are same.
Respondents, especially the purchaser, me.
परचेजर इज सेम
Purchaser
Same.
is
Absolutely. In between, there are transfers. Those transfers are also made parties.
and there are all the purchases in between whatever are the transfers
Yes.
they are transfers post transfer
demise.
to you because
No,
you
first-
say that you are the purchaser when
I am
did
the
you
last
purchase
purchaser. I am the last purchaser.
last
I am
purchase
the last purchaser.
and from whom have you purchased from whom have you purchased
Yeah, that I'll have the last purchaser. There were only two sales. One sale by one of the successor to one person, and from him I purchased. So there are only two transfers.
so you have a chain of transfer
I have a chain of transfer.
is there any parallel chain of transfer
No.
there is no parallel
No,
chain,
no,
of,
only
chain
two.
of transfer
No, not at all.
So you are the last purchaser, and then under such circumstances, the person who had your vendor must
Yes.
be a common party in all the cases.
My vendors are yes.
They are parties.
Yes, they are parties. They are parties. And even the successors are also parties who made the first transfers. So they are also the parties.
So first transferee
Are the parties.
and second
Second transferees are also parties.
transferer.
Yeah, transfer. Sorry. First transferer, second transferer, and I am the transfer. Final transfer.
and purchaser, final purchaser
Yes.
are parties in all the cases.
In all the cases.
Who are the parties who are? Then what is it? What is it in variance?
Yeah. May I explain it? Well, two persons, one Alguram and Jogeshwar Ram, they held 5.1 acres of land together without division of that.
Algu and Yogeshwar.
Algu and Jogeshwar. Yes. And both were brother-in-laws. Yeah, let's see. Both were own brother-in-law. They married the sisters. So, Sadhu. Sadhu.
Own brother-in-law.
Oh, own brother-in-laws. Yes.
Yes. There was no partition with respect to
There was no parties. And both died issueless.
both.
Both. Now, Jogeshwar Ram had three brothers who were alive when he died. Those three brothers, the names are Valmiki, Taraknath, and Bajnath.
Yogeshwar, Valmiki,
Valmiki, Taraknath, and Bajnath.
and
Tarak and Bajnath. Valmiki, Taraknath, Bajnath. Both succeeded. Both survived. Their brothers.
Their three-
brother, Jogeshwar.
three sons.
No.
Valmiki,
Valmiki, Taraknath, and Bajnath were three brothers of Jogeshwar Ram.
Brothers.
Brothers, yes. Own brothers.
Okay.
So they succeeded.
Okay. To the extent of his share.
Yeah, 1/3. 1/3 each.
Why 1/3? There are only two
No,
persons.
Alguram
Algu and Yogeshwar.
is coming from different family.
Maybe, but the property is in joint name of Alguram and Yogeshwar.
No, not joint name. They were holding jointly, not in joint name. मतलब जमीन जो 5.1 एकड़ था उसको उन्होंने डिवाइड नहीं किया, लेकिन पेपर्स उनके अलग अलग थे.
पेपर्स अलग अलग से क्या मतलब? अगर कोई प्रॉपर्टी जॉइंटली किसी के नाम से रिकॉर्डेड है 50-50 समझेंगे ना
50-50, yes.
तो 1/3 की बात कहाँ से?
नहीं, वो 1/3 आया सेकंड जनरेशन.
मतलब ब्रदर का जब
Yes,
brother
brother, जब जोगेश्वर राम की मौत
तो
हुई.
इसका मतलब ये हुआ
Yes.
कि हाफ का 1/3
हाफ का 1/3 2.55 एकड़ का 1/3 इन तीनों लोगों को गया. वाल्मीकि, तारकनाथ एंड बैजनाथ.
ओके हाफ का 1/3
हाफ का 1/3. यस. दूसरा जो हाफ है अलगूराम का, उनके एक ब्रदर है राधा कृष्ण सिंह. उनके बेटा है, उनकी डेथ हुई. उनके बेटा है रामेश्वर सिंह, जिन्होंने हमें अपना, because that land total entire, that is 2.55 acres of land, that entire land 2.55, that is 50% of 5.1 got devolved on him only.
That's right.
Alone.
मतलब
And he has transferred.
सूट प्रॉपर्टी का
Yes.
यानी कि जो प्रॉपर्टी अलगू और जोगेश्वर के नाम से जॉइंट थी
Yes,
उसका
yes.
आधा हिस्सा जो अलगू का था
जी.
उनके बेटे के बेटे ने
उनके भाई के बेटे.
जो भी उसका सक्सेस
हाँ, सक्सेस
ने पूरा का पूरा अलगू राम वाला पोर्शन आपको ट्रांसफर कर
हमको ट्रांसफर कर दिया. Through one, in between there is one transfer, one purchaser, and from him.
दैट्स राइट
Correct.
हाँ.
और इसमें
अल्टीमेटली इट वाज ट्रांसफर्ड
it was transferred to him.
आफ्टर
Now-
हैविंग अ चेन ऑफ ट्रांसफर
Yes, absolutely. Now Bajnath, one of the brothers of Jogeshwar Ram,
यस
he has also transferred his share, 1/3.
ओके 1/3
1/3.
आपका हाफ प्लस 1/3 ऑफ हाफ
1/3. करीब
आपका ये हो गया हाफ प्लस 1/3 ऑफ हाफ
80-85 डिसमिल के आसपास है.
वो 80 हम तो इन टर्म्स ऑफ परसेंटेज
हाँ, परसेंटेज 1/3.
हाफ प्लस 1/3 ऑफ हाफ
1/3 of half.
यानी
Yes.
कि 1/2 प्लस 1/6
Correct.
करेक्ट
Now who are they? Petitioners. ये जो तारकनाथ है, who survived
यानी
his
कि
brother.
2/3
हाँ, total 2/3. Now the petitioners are, your ladyship, the sons of Taraknath. Plaintiffs. Yes, not petitioners.
plaintiffs are in all the
Sons
cases
of Taraknath, one of the brother of Jogeshwar Ram.
तारकनाथ
Correct. So after Jogeshwar Ram died, so let's see, may take the date
तो
also.
उनका तो 1/6 शेयर था
हाँ, उनका 1/6 शेयर था. Correct. Now what is he claiming? All three brothers, son of Taraknath, who is the brother of Jogeshwar Ram, what are they claiming? That Alguram on 24/12/1990, Alguram on 24/12/1990 created a Panchnama, which is a kind of unregistered. गाँव में जो बनता है, he created a Panchnama in favor of Jogeshwar Ram to look after the land. This is their claim. And Alguram died on 21/1996. 24/12/1990 को उन्होंने एक पंचनामा क्रिएट
Date
किया
कब
इन
हुआ?
फेवर ऑफ जोगेश्वर.
डेट ऑफ डेथ
या डेट 21/1996.
20
या 20/1/1996. और उनकी वाइफ का डेथ हुआ 27/7/2001, 27/7/2001। उनकी वाइफ का नाम है दुखनी देवी।
Yes.
So if Panchanama is a power of attorney, it came to an end when he died, that is 21/1996, and his wife died in 27/7/2000.
Panchnama is not power of attorney.
Yeah,
It's
yeah,
a
but
permissive,
this is
permissive
what,
possession.
This is what is written in the order. It has been treated as a power of attorney. Last wish, he has used that term. Last wish.
Last wish मतलब will.
हाँ, वो उसको will के रूप में ट्रीट कर रहे हैं। मतलब
Power of attorney नहीं will की। दोनों में फर्क है ना? ये दोनों सेम है। Power of attorney और will में फर्क है ना?
दोनों बिल्कुल अलग है। Panchanama is different thing.
आपका क्या है वो पंचनामा क्या चीज है?
पंचनामा जैसे
आपके अनुसार वो क्या है? पावर ऑफ अटॉर्नी है कि
power of
will है
attorney
कि
तो बाद में
परमिसिव
वहाँ-
पोजीशन?
power of attorney तो बाद में
कि
वहाँ
परमिसिव
cabinet में हो
पोजीशन है?
Panchanama is not a will. Panchanama is that I have, I wish that I am giving my land to, but Panchanama, date of Panchanama here is different, and power of attorney date of is different.
पावर ऑफ अटॉर्नी का डेट?
Yes, that is
Now
18
now
8/11/2000.
Jogeshwar Ram is claimed to have created a power of attorney on 8/11/2000. 8/11/2000 को इनका मानना है, because both these documents are declared forged also in the second order, in the last order. 8/11/2000 को जोगेश्वर राम ने एक पावर ऑफ अटॉर्नी दिया।
एक सेकंड लिखिए तो। The learned counsel for the appellant has submitted that in all the cases the suit property is one and the same. आप सुनिए प्लीज। Yes, please focus on what आप लोग का जो डिस्कशन है ना चेंबर में किया करिए।
Yes.
आपके सामने लिखा रहे हैं आपका सबमिशन, तो ध्यान दीजिए प्लीज। The learned counsel for the appellant submit that in all the cases the plaintiffs are the same and the property involved in the case is also one and the same. The last purchaser of the property in all the cases
Same.
is the same. He has submitted that there is a chain of transfer and the last purchaser is the second purchaser of the property.
Absolutely.
The property was standing in the एक सेकंड रुक जाइए उनका।
ये सेकंड नहीं है, उसको खाली करेक्ट करना, थर्ड है वो।
अच्छा आपकी बात लिखाएंगे, इनका सेकंड बोल रहे हैं रहने
जी।
दीजिए। ये थोड़ा कैप्चर करना जरूरी है चीज़ों को समझने के लिए। आज तो नहीं हो पाएगा लेकिन ये फाउंडेशनल बैकग्राउंड हो जाएगा तब अगला रेट में हो जाएगा। ठीक है,
ठीक।
He submits that the property stood recorded in the name of Algu.
Algu. ALG.
Algu.
Algu.
Yeah, in the name of one Algu and Jogeshwar.
Jogeshwar. Yes.
They were own brother-in-law
Yes. Absolutely.
and their wives were attending own brother-in-law company. And there was no partition amongst the two. He further submits that Jogeshwar died leaving the share of Jogeshwar devolved upon his death on three brothers, namely Balmiki, Taraknath and Vaisnath. And thus, half of the total property devolved upon the three brothers, and consequently each one of them got 1/3 of half of the property. He further submits that Algu also expired, leaving behind his one son.
No, his brother.
Leaving behind his one brother who had one son, and he transferred the entire share to the extent it related to Algu to the appellant. And further 1/3, further Bajna transferred his portion of the property to the appellant. Consequently, the appellant got half share of the total property which was belonging to Algu and 1/3 share of the remaining half
Yes.
which was belonging to Jogeshwar. Consequently, the 2/3 of the property was purchased by the last purchaser.
Yes, that's the case. Grateful.
He has further submitted that Alguram had expired on 21/1996 and his wife Dukti Devi expired on 27/7/2001 and there was an unregistered Panchnama dated 24/12/1990 in favor of executed by Algu Ram in favor of Jogeshwar Ram
Purportedly, because that was
purportedly
that was
ये वाला
declared-
unregistered Panchnama
Yeah,
purportedly
that was declared forged. So,
in favor of Jageshwar Ram and one power of attorney was also executed by Jageshwar Ram
Jogeshwar. J-
on 8/11/2000
Yes.
and this power of attorney ये भी purported है
ये भी purported. Yeah, both.
purported power of attorney was executed in favor of Jageshwar Ram dated 8/11/2000 which included the property which was belonging to which was falling in the share of Alguram.
Yes, absolutely. Entire 5.1
Entire.
they are claiming. Yes, absolutely.
Which included the entire property
Entire
of Alguram and
Jogeshwar. Right.
Jogeshwar Ram.
Yes.
Alguram and Jogeshwar Ram. Okay.
Jogeshwar died on 16/11/2000, just
And
after 7 days.
Jogeshwar Ram expired on 16/11.
16/11, after 7 days. 7 days of
16/11.
2000. 2000, yes, after 7 days. And his wife had already died sometime in August 2000. That they have stated in their
And his wife had predeceased him,
predeceased. Yes.
who expired sometimes in the month of August 2000.
Yes, yes, that's the case.
तो लड़ाई कहाँ पर? Where is the fight?
Now, plaintiffs claim that through these two power of attorneys, or whatever that may be called,
This Panchnama and this
power of attorney,
power.
dated 8/11/2000, all the
exhibit
land.
क्या है ये? Exhibit number?
Panchnama is exhibit 5 in TS number 46.
और ये 8/11/2000
Yes.
power of attorney. Power of attorney.
Power of attorney.
Title suit
General
number
power of
46
attorney,
of which
exhibit
year?
3. Exhibit 3 is that is in ये है ये अपील नंबर
नहीं आप अपील नंबर से मत बताइए.
TS नंबर से हाँ टाइटल सूट 46 में
of
ये एग्जिट टाइटल नंबर 46 ऑफ 2012
2012
yes
and which is the corresponding appeal?
46 का corresponding appeal is 77
77 of
77 2023.
The learned counsel has submitted that the Panchnama dated 24/12, the alleged Panchnama dated 24/12/1990 is Exhibit 5 in title suit number 46 of 2012, which is subject matter of consideration in first appeal number 77 of 2023.
Yes.
He has also submitted that so far as the power of attorney dated 8/11/2000 is concerned, the same is Exhibit 3
3.
in the same proceedings.
Yes.
तब तो आपको ये टाइटल सूट 46 वाला 77 आप पहले बहस करना चाहेंगे?
कुछ फर्क नहीं, क्योंकि हमको ये आसान था कि हम नोटिंग इसमें किए थे, इसलिए इससे बताए। दोनों में है, इससे कुछ फर्क नहीं पड़ता।
He has submitted that these exhibits are available in the other
Yes.
records also.
Yes.
अब बताइए क्या लड़ाई है?
Now they say that because of these power of attorneys, they became the owners of this land. As per
So
them.
finding it.
Now finding is that that was allowed in my case, but in their case it was not allowed, because those were found as forced as per the submission of that is PW6, petitioner witness 6. As per his submission only, it was found forced कि उसको ये पंचनामा को किसी रामकेश्वर ने लिखा है, so obviously not by Algu, and nobody has seen that. So that is recorded in the order also. Now in the order says power of attorney does not confer any right, title, interest, as is well known. Another thing that it has considered in his appeal, that they did not have any documents of title to come before the court. That is the mandatory.
Who are they?
The plaintiffs.
Representing whom?
They were representing themselves.
They must be claiming themselves to be the legal here, or how are they related?
They
to
are
everyone?
saying that we are nephews. They are excluding the three brothers. अपने फादर को भी बाहर कर रहे हैं, वाल्मीकि और बैजनाथ को भी बाहर कर रहे हैं, जिन्होंने ट्रांसफर किया है हमको। इन सबको बाहर करके बोल रहे हैं इन तीनों में से किसी का लैंड नहीं है, हमारा है, on the basis of these two power of attorneys. Now these two power of attorneys have been declared
Nephews
forced.
of whom?
Nephew of जोगेश्वर राम. मैं फिर से कनेक्ट करता हूँ। अलगू राम ने 1990 में एक पंचनामा दिया इन फेवर ऑफ जोगेश्वर राम। जोगेश्वर राम ने एक पावर ऑफ अटॉर्नी दिया इनके फेवर में, जो प्लेंटिफ जो क्लेम कर रहे हैं, ऑन 8/11/2000. So now they say on the basis of 8/11/2000, the entire 5.1 acres of land devolved upon them, excluding their own father and two uncles. There was no will. There was no will. All three brothers survived, but they are saying that as per these two power of attorneys,
इनके फैमिली में भी आपस में डिस्प्यूट है क्या?
इनके आपस में बैजनाथ के साथ तो इनका डिस्प्यूट है, because बैजनाथ is on my side. He is defendant number 3 in perform, and very surprisingly they have not claimed any relief against the transferor, first transferor, that is Rameshwar Singh. There is no relief. They have claimed cancellation of my deed, but not the previous deed. It is there in their petition, in their prayer, and the court has ignored that.
The learned counsel has also submitted that the plaintiffs are claiming, by virtue of being the power of attorney holder, in terms of the document dated 8/11/2000 within bracket Exhibit 3, and claim the entire property. And since power of attorney was executed by Jogeshwar Ram in relation to the entire property, they exclude all other relatives.
Correct. Three brothers, father and two uncles. They exclude their own father and two uncles.
And they exclude their own father, namely
Tarak Nath is the father, and other two uncles, Valmiki and Baijnath.
their own father, namely Tarak Nath,
Yes,
and also Valmiki and Vaishnav.
two uncles, correct.
And consequently there is a conflict between the power of attorney holders by virtue of alleged Exhibit 3 and the three brothers of Jogeshwar, namely Valmiki, Taraknath and Vaishnav.
Right. Yes.
He has also submitted that the plaintiffs in their relief did not challenge the initial sale deed,
Yes, absolutely.
and they have only challenged the subsequent sale deeds.
Last sale deed, that was 2 million.
They only challenged the last sale
Last
deed.
sale. Yes.
And consequently the sale deeds in favor of the vendors of the last purchaser
Yes.
through a chain of transfer remained intact.
Intact. Correct.
यही है आपका पूरा
Yes,
बैकग्राउंड.
yes, yes.
इसमें से क्या चीज गलत बोले हैं और क्या चीज सही बोले
First transfer.
हैं? जिनोलॉजी सही बताए हैं.
Chinology to Sri Rameshwar, so far Rameshwar Singh is concerned, specifically, he is the first transferor. In first two cases, that is 44 and 77, Rameshwar Singh has no relation at anywhere with Jogeshwar Singh or Algura. That is finding of the court below. Therefore, his
Rameshwar Singh is a stranger.
Rameshwar Singh is a stranger. First, a power of attorney is given to him. He has transferred the land to the company. My lord, I am 77. I am party details is here.
नहीं आप हमको बताइए ना, मोटा मोटी बताइए आप.
हाँ, तो ये कोर्ट का फाइंडिंग है कि रामेश्वर सिंह जो है ये किसी तरीके से
ये राधा कृष्ण सिंह के बेटे नहीं थे.
उनके बेटे हैं, लेकिन राधा कृष्ण सिंह जो हैं
अलगुराम के बेटे नहीं.
नहीं, वो वृक्ष सिंह के
अलगुराम
बेटे
के ब्रदर नहीं है.
नहीं, ये आया है उनका कोई नहीं है, वो वृक्ष सिंह के बेटे हैं,
अलगुराम के भाई भी नहीं है.
भाई भी नहीं है, जोगेश्वर राम से भी उनका रिलेशन नहीं है. तो ये आया है नीचे कोर्ट के फाइंडिंग में. और चूंकि अब दोनों केस इसी ग्राउंड पे इनका जो है
The learned counsel appearing on behalf of the plaintiff and respondent in all the cases. आप सारे cases में
not in all the cases.
respondent in first two number बताइए.
77 and 44.
77 of 2023 and 44 of 2023 has submitted that the first transfer was made by Rameshwar Singh, who is son of Radha Krishna Singh, but he was not at all related with Jogeshwar Singh or Algu Singh. And therefore, property of Jogeshwar Singh or even Algu Singh never devolved upon Radha Krishna Singh and then to Rameshwar Singh, and therefore the transfer has been made by persons completely stranger to Jogeshwar Singh and Algu Singh,
Yes.
and therefore, and this finding has been recorded by both the courts.
Yes.
He has submitted that there was no need to separately challenge the sale deeds which were executed by complete strangers to the property. यही है ना आपका केस टोटल.
हाँ, ये तो इस दोनों में यही है. एक 156 अलग
156 में क्या है आपका?
156 में बैद्यनाथ सिंह ने ट्रांसफर किया है, तो वो तो इनके आते हैं, लेकिन हमारा वो केस है कि उसमें क्योंकि जमीन जो है हम लोग को पंचनामा से इनके जोगेश्वर सिंह को दिया अलगुराम जी ने. जब जोगेश्वर सिंह हैड given a power of attorney to the plaintiff, so they came in possession of all the land and they are.
Power of attorney दे देने से ओरिजिनल ओनर का राइट खत्म हो जाता है.
Land was self-acquired. That is not ancestral land.
Even if
तो
How does that mean?
self-acquired land है, they are issued, तो उन्होंने वो किसी को भी दे सकते हैं.
the power of attorney से ट्रांसफर होता है.
That has not been transferred. That is true. That is there. But land
So
is,
therefore,
but land is cannot come in share of his brothers because it is self-acquired land. He can give it by panchanama or power of attorney to any.
no, he can't transfer it by way of power of attorney.
Transfer.
Power of attorney से अगर सेल डीड हो गया उनके मरने के पहले, तब तो बाइंडिंग है.
His sale deed is not there, but he has given through panchanama, and there are power of attorney. I have given my land to him. It's my self-acquired land. So my brothers has no rights in my land.
That's right.
That's not ancestral. That is my case.
With respect to first appeal number 156 of 2023, the learned counsel for the plaintiff in the same case, who is the appellant
Appellant in third case.
in first appeal number 156 of 2023 has submitted that the property was transferred by Baijnath, brother of Jogeshwar, but Jogeshwar had already given Panchnama in favor of the plaintiff on 24/12/1990, and the property was also included in the power of attorney dated 8/11/2000, and consequently Baijnath had no right to transfer the property. He has submitted that the property was not the ancestral property of Jogeshwar Singh, but it was the self-acquired property, and he could have handed over the property through Panchnama or through power of attorney. And having executed the Panchnama or power of attorney in favor of the plaintiffs, and Baijnath having no right to Baijnath being brother of Jogeshwar did not have any right to transfer the property, and consequently the sale deed executed by Baijnath was itself null and void. यही है आपका. इतना तो हो गया बैकग्राउंड. अब इन फाइल में से कौन सा फाइल आप लोग चूज करेंगे सबसे पहले बहस करें?
I'll start with 44.
आप बताइए. 44 ठीक है.
कोई भी कर सकते हैं. 44 और 77 दोनों में से कोई एक तो डिफरेंट हो ही गया. 156 तो थोड़ा डिफरेंट हो ही गया.
Different.
तो either 44 और 77 दोनों में कोई भी चूज
The
करें.
learned counsel
They
for
are
the
same.
parties have also submitted that so far as first appeal number 156 of 23 is concerned, the same is in relation to the sale deed executed by Baijnath, brother of Jogeshwar,
Yes.
and will stand on different footing as compared to the other two first appeals, as the other two first appeals relate to the property of Algu, right? उसमें तो बैजनाथ का प्रॉपर्टी नहीं है इनको.
No.
Properties
These
of-
two are identical. 44 and 77.
They submit that first appeal number 44 of 23 and first appeal number 77 of 23 be taken up again at the first instance. अब क्या करेंगे? करेंगे तो करिए,
अभी
या फिर कोई नोट बनाइए. देखिए इतना बैकग्राउंड तो क्लियर हो गया ना.
clear. Yes.
ठीक है.
रिटन नोट्स के लिए कहा जा रहा तो बना के दे
नहीं, आपको बनाना जरूरी है ना, नहीं तो हम जजमेंट कैसे लिखाएंगे?
दैट्स ट्रू. दैट्स करेक्ट.
ऐसा थोड़ी होगा. तो सारा काम हम ही करेंगे, आप लोग क्या करेंगे? आप बनाइए और पूरा एकदम फ्लो चार्ट बढ़िया से. ये तो ऐसा लिखाए हैं लेकिन प्रॉपर फ्लो चार्ट बनाकर, ठीक है. और आप लोग जॉइंटली बना दीजिए. जहाँ जहाँ डिस्प्यूट है लिख दीजिए डिस्प्यूटेड बाय सच एंड सच. उससे क्या होगा कि
एक ही देखना पड़ेगा.
एक ही देखना पड़ेगा और कहाँ पे डिस्प्यूट आ रहा है
कंपाइल्ड रहेगा.
उसको देखना. और ये जो एग्जिबिट्स है आपका पावर ऑफ अटॉर्नी वाला और पंचनामा है, इसको अलग से आप हमको प्रोवाइड भी कर देंगे, तभी उसका क्या इम्पैक्ट है, क्या नहीं है, हम देखेंगे. फर्स्ट अपील है ना, डॉक्यूमेंट तो देखना पड़ेगा.
तो 10 दिन का समय दीजिए.
हम आपको 10 दिन का नियम होली के बाद रखेंगे.
थोड़ा सा
हम ज़्यादा
आफ्टर
समय
21st. आफ्टर 21st हम बना के इनको भेज देंगे. और इसमें एक कॉलम इनके लिए रहेगा कि जहाँ जहाँ इनका डिस्प्यूट है, दैट कॉलम कैन बी फिल्ड अप बाय हिम एंड देन द सेम थिंग बाय साइन बाय बोथ द पार्टीज, बोथ द प्लेटफॉर्म्स. आप अपना उसमें डाल दीजिएगा और सारा चीज़
देखिए आपको हम बताते हैं इस
Fact तो
तरह
हम
के
बदल नहीं
मैटर्स
सकते.
को कैसे करते हैं. ठीक है, आप अपना बना के भेज दीजिए पेज वाइज. ही कैन कमेंट कि इसमें कोई डिस्प्यूट नहीं. पेज नंबर 1 नो डिस्प्यूट, पेज नंबर 2 ये डिस्प्यूट है. तो उससे क्या होगा कि पूरा पिक्चर एकदम clear रहेगा, and then we'll see those documents simultaneously
Correct.
and then proceed.
As you wish.
ठीक है?
Absolutely.
और सबसे इम्पोर्टेंट है आप अपने रिटन नोट्स में क्या प्रेयर है, रिलीफ क्या है, ये देना बहुत ज़रूरी है कि व्हाट रिलीफ हैव यू प्रेड. वैसे तो बहुत एपरेंट होता है लेकिन नोट बना रहे हैं तो उसी अनुसार करें. ठीक है?
इसको
Having given the factual background of the cases, both the parties have submitted that they would prepare written notes on the factual aspect and also indicate the point of dispute in the written notes so that the matter can be finally heard on the next date. बताइए कौन सा दिन रखें?
after 4 weeks.
आप जो डेट बोलेंगे रख देंगे, लेकिन
बिल्कुल,
उसके
सर।
बाद जो है ना सुनेंगे एकदम पूरा.
हम तो तैयार नहीं कर 4 weeks का कोई डेट रख दीजिए 7th और 11th अगर पॉसिबल है.
7th और 11th
कोई
March.
कोई एक दिन नहीं अप्रैल
April.
आफ्टर 4 weeks कंप्लीट 4 weeks अगर है
हाँ, एकदम.
पॉसिबल है.
Post this case on post this case on 7th of April 2025 to be taken up at 2:15. If the matter does not conclude on 7th, it will continue on 18th.
Great.
ठीक है?
Yes.
Final disposal. Final disposal होगा ना?
There may be a direction for paper book.
The written notes etc. should be filed by 3rd April. आप लोग फाइल कर देंगे 3 अप्रैल तक आप.
And registry must be having the bill of
नहीं, यहाँ पर आपको रिकॉर्ड से आप रिकॉर्ड से देख सकते
LCR must be there
हैं.
here.
LCR था?
And
Yes.
Require those power of attorney. We have a copy, but it's not very legible. So
आपको सर्टिफाइड कॉपी नहीं दे सकते क्योंकि यहाँ पर आता नहीं है सर्टिफाइड. आप देख सकते हैं रिकॉर्ड पे जो है.
the paper book, if we can apply from the office and we can get.
नहीं मिल सकता ना आपको, उसका पेपर बुक नहीं बनता है क्योंकि फोटो कॉपीज आते हैं.
you inspect and take note. Also page number 6. That will help.
रिकॉर्ड हम रखवा देते हैं यहाँ पर, आप तो जब मनो देख लीजिए.
Because that will save time.
तो बहुत ज़्यादा लंबा हो
Yes.
जाएगा रिकॉर्ड.
It will save a lot of time if I have the numbers also. You can just take
To
note of
exhibit or
page
check.
numbers. So it will just take minutes time to shift from.
The learned court master is directed to retain the records of these cases received from the concerned court so that the councils may inspect the records.
Much okay.
Very much.
Also case item 1, second appeal 157 of 2019.
Where is Mr. Kaushik Sarkar? अभी वो दूसरा कोर्ट में चले गए होंगे. कोई कोर्ट में आधा घंटा तो बहस नहीं होता है. होता है क्या? ऐसा नहीं होता है. अनलेस फाइनल हियरिंग का कोई मैटर नहीं हो, आधा घंटा बहस नहीं होता.
फाइनल हियरिंग.
फाइनल हियरिंग होता है. बट हियर इज आल्सो नॉट हियर. आप बहस करिए, छोड़िए ना उनको. आएंगे तो बहुत अच्छी बात है, नहीं तो ऐसे भी डिसाइड कर सकते.
Lordship may kindly see me, Lord, the order dated 13/2/2025, order number 11.
हाँ.
By which, my Lord, additional substantial question of law was formulated as to whether Exhibit 4 was effecting partition and compulsorily registerable as per section 17 and 14 of the Registration Act, or it was just a memorandum of earlier partition. And Lordship may kindly see para 6, my Lord, whether oral family settlement Exhibit 4 entered into between the sons with respect to the property acquired by their father during his lifetime without making doubters as party to the said deed is binding upon the parties, and whether the findings of the learned appellate court is perverse and against the mandate of law. Now, Lordship may kindly see This is, my lord, the defendant's second appeal against the judgment of affirmance.
इन इशू को हम लोग तभी टच करेंगे,
Lord.
आंसर करना है,
Lordship.
लेकिन पहले आप ट्रायल कोर्ट से
जी,
केस ऑफ रेस्पेक्टिव पार्टीज
पहले वो एग्जिबिट 4 दिखा देते हैं, उससे क्लियर हो जाएगा, क्योंकि एग्जिबिट 4 पे ही है वो
ठीक है, बताइए
फाइंडिंग भी
exhibit four।
रिकॉर्डेड
हाँ,
है।
बताइए।
एग्जिबिट 4 केवल देख लिया जाए कि ये मेमोरेंडम ऑफ पार्टीशन है या डॉक्यूमेंट ऑफ पार्टीशन, तो इट विल बिकम क्लियर।
एग्जिबिट 4 पढ़िए।
Now lordship may kindly see. It is this is my lord with respect to the suit property. Now lordship may kindly
ऊपर से
see.
पढ़िए पूरा,
जी,
टॉप से।
पारिवारिक आपसी मौखिक बंटवारा का निर्देशन पत्र। Now lordship may kindly see. प्रथम पक्ष they are my lord
दलील दाता, देखिए कोई भी वर्ड
दलील दाता प्रथम पक्ष, ये है जो ठाकरी पोद्दार, वाइफ ऑफ लेट मोती पोद्दार, काशी पोद्दार, सन ऑफ लेट मोती पोद्दार,
यस,
मीना देवी, वाइफ ऑफ मोती पोद्दार,
मीना देवी सेकंड,
daughter of मोती पोद्दार।
daughter is there, all the daughters taken,
daughter of Moti Poddar,
okay,
daughter of Narsingh Poddar, my lord, they have not been made parties. Property belongs to Narsingh Poddar. Daughters have not joined.
then why this Moti Poddar, his wife is there?
Because my lord, Moti Poddar died. Therefore, my lord, according to the case of the plaintiff, there was an amicable partition between the legal heirs of Moti Poddar and Shyam Poddar.
Shyam, just a moment, partition, and Shyam Poddar.
Lordship.
Yes,
And my lord, they are pro forma defendants in this suit. They have transferred, my lord, the suit property in favor of the plaintiff.
so we will come to that later.
Lordship.
We do not know what is the
Lordship.
story. We just want to look at the document and find out
Lordship.
it's a
Lordship.
memorandum
This
or
much,
it's a.
this much only.
Let's read it, please.
Lordship. दलित दाता द्वितीय पक्ष श्याम पोद्दार. Now my lord may kindly see. आज दिनांक 20/11/2005 को दोनों पक्षों के बीच एक समझौता हुआ जो निम्न प्रकार 20/11/2005 पहले का कोई प्रीवियस पार्टीशन का जिक्र नहीं, 20/11/5 को हुआ। अब इसका टर्म्स देखा जाए। 1 विदित हो
Just a moment.
लॉर्डशिप
This is compromise on
दोनों पक्षों के बीच समझौता हुआ जो
2011
लॉर्डशिप
and this document is dated?
dated 2011.
Okay.
Now lordship may kindly see terms of this memorandum. विदित हो कि पूर्व में बंटवारे किए गए संपत्ति में जो निबंधित पारिवारिक बंटवारा के द्वारा नरसिंह पोद्दार को मिला not with respect to the suit property. This is, my lord, with respect to the ancestral property which was allotted in the share of नरसिंह पोद्दार. उस पर नरसिंह पोद्दार के दोनों पुत्र का बराबर हक बनता है. This is, lordship, not with respect to the suit property.
Suit property is relating to?
Suit property, lordship, measuring an area of 1 decimal.
No, it is not belonging to Narsingh Poddar.
No. This is, my lord, with respect to the ancestral property. विदित हो कि पूर्व में बंटवारा किए गए संबंधित में जो निबंधित पारिवारिक बंटवारा के द्वारा नरसिंह
So
पोद्दार.
there is already a registered partition.
Registered partition, not with respect to the suit property. Registered partition with respect to the ancestral property which was allotted in the share of Narsingh Poddar.
Who is Narsingh Poddar?
Narsingh Poddar, my lord, purchased the suit property by virtue of registered sale deed.
This ancestral property.
नरसिंह पोद्दार, my lord.
देखिए आप ना सूट का स्टोरी में मत आइए.
हाँ बता. सूट का.
नहीं मत आइए क्योंकि we are going to read this document as it is.
हाँ ठीक है.
Right.
ठीक.
अब सूट तो अभी तक आप प्लेस नहीं किए हैं. You said कि exhibit 4 पहले देखते हैं whether it's a partition
हाँ.
or it's a memorandum.
इसी को देख.
तो आप बस उतना ही पहले आप इसको पूरा प्लेस करिए
हम
ना,
इसी
उसके
को-
साथ साथ कमेंट्री मत
नहीं
करिए, वैसा नहीं हो.
हुजूर पूछे इसलिए बताया.
ठीक है.
ये हो
आगे।
गया 1 हुजूर. 2 देखा जाए. दुर्भाग्यवश नरसिंह पोद्दार के पुत्र मोती पोद्दार का स्वर्गवास अचानक हो गया.
बढ़िया आगे.
विदित हो कि जब तक नरसिंह पोद्दार जीवित थे, उनके स्वर्गीय पुत्र मोती पोद्दार के वंशज और जीवित पुत्र श्याम पोद्दार नरसिंह पोद्दार की जमीनों को इकट्ठे दखल करते थे, पर नरसिंह पोद्दार की मृत्यु के पश्चात मोती पोद्दार के वंशज एवं श्याम पोद्दार में अनबन होने लगा, पर पारिवारिक को मद्दे नजर रखते हुए दोनों ने उक्त जमीन को 2 बराबर हिस्सों में पारिवारिक रूप से आपसी सलाहानुसार बांट लिया. जिसमें 1206 दाग में आधा डिसमिल और 1206/2305 में आधा डिसमिल कुल 1 डिसमिल जमीन दक्षिण और मोती पोद्दार के सर्वज दलील दाता प्रथम पक्ष को मिला.
आगे.
जबकि उन दोनों के दागों में बराबर जमीन उत्तरी छोर में दलील दाता द्वितीय पक्ष श्याम पोद्दार को मिला.
बढ़िया बढ़िया.
विदित हो कि मोती पोद्दार की विधवा स्त्री ठाकरी पोद्दार को पैसों की सख्त जरूरत है, इसलिए ये चाहें तो निजी अंश को बिक्री कर सकती हैं. Thereafter, Lordship, Lordship, उल्लेखनीय है कि पंच भद्रों के समक्ष दोनों पक्ष को इस पारिवारिक बंटवारा को स्वीकार किया और दोनों पक्षों के कहे मुताबिक निदर्शन के लिए एक सादा कागज पक्षकारों के दस्तखत लेते हुए बना दिया ताकि भविष्य में काम।
म्यूटेशन कब हुआ, इसके बाद किसके पहले?
लॉर्डशिप,
म्यूटेशन कब हुआ, इसके बाद किसके पहले?
म्यूटेशन तो बाद में हुआ, 2008 में से लीड एग्जीक्यूटिव, ये तो 2005 का है।
ठीक है, क्या बोलना है आपको इसके बारे में?
My submission is, my lord, that this document cannot be termed as memorandum of partition. Rather, my lord, recital of this document would go to show that the property is being partitioned amongst the heirs of Moti Poddar and Shyam Poddar. And Lordship, my submission is that this is, my lord, a document of partition, and until and unless, my lord, it is impounded in accordance with the provision contained in section 35 of the Indian Stamp Act,
स्टैम्प एक्ट में कहाँ हुआ?
it cannot be looked into
नहीं,
even
नहीं,
for
नहीं,
collateral
no,
purpose.
no, no, no. मेमोरेंडम ऑफ पार्टीशन के लिए कोई स्टैम्प पेपर की जरूरत नहीं।
Memorandum of partition.
If it is a memorandum of partition, you don't.
If it is a memorandum of partition, I have no case.
Yes, that's right.
This is my
You
submission.
see,
If it
सीधा
is a-
सा इतना ही बात है।
जी।
देखिए, स्टैम्प एक्ट का कोई इशू नहीं बना है। स्पेसिफिक इशू है सेक्शन 17 एंड 49 ऑफ द रजिस्ट्रेशन एक्ट।
उसी पे बोल रहे हैं।
उसके बियॉन्ड मत जाइए।
ये चूंकि एग्जिबिट हुआ ना, तो अगर पार्टीशन का कोई भी डॉक्यूमेंट होगा हुजूर, सुप्रीम कोर्ट का जजमेंट कि अगर ये इम्पाउंडेड नहीं है,
देखिए, जो इशू बना नहीं है
वो इशू उस इशू पे नहीं जा रहे हैं।
बस इतना ही पर आप रहिए कि ये कंपल्सरीली रजिस्ट्रेबल
बस उतना ही है।
बस उतना ही इशू बना है।
हाँ।
उसके बियॉन्ड तो
नहीं,
इशू नहीं
उसके
बना।
बियॉन्ड हम नहीं, बस उसके
उसके
बियॉन्ड
बियॉन्ड की बात ही मत करिए।
उसके बियॉन्ड हम
So
आर्गुमेंट
according to you, this is a document of partition compulsorily registered.
रजिस्टर। And my lord, doubters of nursing Poddar,
नहीं, it's
they have not joined. नहीं, इशू है हुजूर,
हाँ, ठीक है। Daughters of nursing Poddar have not joined this.
not
petition.
joined.
That substantial law, substantial question of law has not been formulated.
It
नहीं,
has
नहीं,
been
formulated.
बताइए, आप substantial question of law भी नहीं पढ़े हैं?
एकदम
You're
formulated
arguing
बात
second
देखिए,
appeal.
ये
No, मतलब non-joint है.
Yes.
formulated हुआ है।
One question of law is the last date it was formulated. The reform.
दो पॉइंट है, दो क्वेश्चन।
बस दो।
अब आप ट्रायल कोर्ट का फाइंडिंग्स
जी
केस ऑफ रेस्पेक्टिव पार्टीज ट्रायल कोर्ट से शुरू करेंगे. व्हाट वाज द केस फॉर?
जजमेंट से पढ़ें या हुजूर को बता दें ऐसे?
जजमेंट से
ठीक कोई. The plaintiff Sukhdev Pandal has brought the suit for declaration of right, title and interest over the suit property in his favor.
You can come to the next paragraph.
Lots.
Case of the plaintiff.
The case of the plaintiff as per his plaint is that the land described in the schedule of the plaint and shown in red color in the annexed trace map originally belonged to Kartar Saw and Ramdhani Shaw within Khata number 106 of the 4115 of Moja Karma Town, which is a Basaudi and sellable land, and Narsingh Poddar, son of late Raghu Poddar of village Posta, P.S. Narayanpur, had purchased 2 decimal of land from plot number 1206 and 1206 of the 2305 of Moja Karma Town from the rightful owners and descendants of Kartar Saw and Ramdhani Saw by a registered deed of sale. And thereafter Narsingh Poddar entered into possession over all that 2 decimals of land and used to possess the same by constructing some tiled roof houses having transferable Basaudi right thereon. It is the case of the plaintiff that Narsingh Poddar died in the year 1999, leaving behind his heirs one son Motilal Poddar and another son Syamlal Poddar. And out of them, Motilal Poddar died premature death in the year 1987. And under law after the death of Narsingh Poddar, both the brothers or their legal heirs have succeeded the purchased portion of land and started possessing the same peacefully. It is also the case of the plaintiff that after the death of Motilal Poddar, Syam Poddar started creating various disturbances and ultimately the purchased 2 decimal properties with structures thereon have been amicably divided. Northern 1 decimal of land has been allotted to Syam Poddar, whereas the southern part of 1 decimal has been allotted to the heirs of Moti Poddar. And a memorandum of partition to that extent was created, this is important Lordship, for future reference on 2011-2005. It is also case of the plaintiff that after the death of Moti Poddar, his widow and children have started living at village Posta, P.S. Narayanpur, and taking advantage of the death of Moti Poddar. Defendant number 1, Syam Lal Poddar, made up his mind to grab 2 decimals of land illegally, and being informed the pro forma defendants took several preventive measures but of no result. It is so case of the plaintiff that on account of manifold litigation cropping up between the parties, the pro forma defendant could not incur the expenditure of the court procedure, and as they were in need of money, they sold their allotted 1 decimal of land to the plaintiff by a registered deed of sale, bearing sale deed number 493 dated 28/10/2008, and thereafter the plaintiff became the rightful owner of 1 decimal of land with a structure thereof. It is further case of the plaintiff that as the principal defendant was adamant on creating troubles on account of
This is about cause of action.
Lordship.
What about the defendant's case,
Lots.
Shyamlal Poddar?
The defendant number 1, Syam Lal Poddar, appeared and filed written statement stating therein that there is no cause of action and the suit is
बाकी तो
not
formal है नीचे.
easy.
It is a case of
It
the
is the case of the defendant number 1 that the plaintiff has a jewelry shop at Karma Town where defendant number 3, Kasi Poddar, works under him as his
उसके नीचे.
employee.
It is a case of the defendant. The suit is bad for non-joinder.
Non-joinder of party As all the heirs of Narsingh Poddar, the original owner of suit land have not been made party. As per this, defendant Narsingh Poddar had three daughters, namely Amli Devi, Bhumi Devi and Santi Devi. The first of whom died on 1/10/2008, leaving her five
ये
sons.
सब genealogy है.
Lordship.
It is also the case of the defendant. As Narsingh Poddar did not die in 1999,
Died in 1999,
but he
died on 26/5/1998, and left behind two sons and three daughters. And next year, the two sons of him never succeeded to the purchased portion of land and possessed the same peacefully. It is also the case of the defendant that before and after the death of Moti Poddar, the pro forma defendants always lived at Posta and they had no occasion to live at Karmata. It has also been pleaded on behalf of the defendant Syam Lal Poddar that the pro forma defendants were never the owner of 1 decimal of land, were southern side, and their alleged sale of the land to the plaintiff is malafide. As per this defendant, the pro forma defendant contested several cases under section 144 and 107 of CRPC for the suit land and got such proceeding drawn up by making false allegations, and in all those cases he had clearly asserted in his so-called that the pro forma defendants have no right title interest in the suit land, nor they are in possession of the same, and that the real owner is the suit land is Leelavati Devi, who has obtained the property from Narsingh Poddar through gift, and she is in peaceful possession thereof by constructing a pakka house thereon. And all those cases were decided against the pro forma defendant. And finding that they will never succeed in their false claim, the plaintiff came to their rescue and got a fixer sale deed prepared on 2010-2008 till the proceeding pendency of proceeding of 144 CRPC. The defendant Syam Lal Poddar has pleaded that the plaintiff has never become rightful owner of the suit land, since the vendors themselves had no title over the same and the plaintiff's sale is entirely God. And the facts are that Narsingh Poddar had become the exclusive and sole owner of 2 decimals of land of plot number 1206 and 1206 of the 2305 of Moja Karma town on purchasing the same, and he built a tiled roof house on the land in question and lived there with his younger daughter-in-law. Leelavati Devi, who used to nurse and do him after during his
just
old age.
just one moment. The plaintiff had purchased the property from Leelavati Devi.
No.
They had purchased the property from whom?
From pro forma defendants.
Legal use.
नाम बताइए ना.
From the legal heirs of Moti Poddar.
Moti. Okay.
Lordship.
And this lady is claiming a gift.
Sada gift, Lordship. Sada gift by Narsingh Poddar.
Why her role is important?
No.
It's not it.
No.
Not relevant.
No.
Okay. Then what were the issues framed?
Lordship may kindly see me, Lordship. Paragraph
Who are
6.
defendant number 2, 3 and 4 and 5? They are the. Who are they? 2, 3, 4 and 5. They are the descendants of
Moti Poddar.
Moti Poddar.
Lord.
Okay.
Issues, Lordship may kindly see para 6.
Para 6. Issue number 5 has been decided. You are not concerned. 5 and 6
No,
has been.
Lordship.
You are not concerned. You are concerned with which issue?
Issue number, Lordship, 4.
4. Only issue number 4 is sufficient?
4 and Milord 3 and 4.
3 and 4.
Non-jointer of necessary party, Lordship.
Let us see the findings.
Lordship.
Yes. बताइए.
Out of 7 issues, has the plaintiff right title interest over the suit property. It is the case of the plaintiff by para 15 of the plaint that the pro forma defendant Thakri Devi, Kasi Poddar and Meena Devi, who are defendant number 2, 3 and 4 respectively, were in need of money and hence they
कौन सा पैरा please? कौन सा
para
पैरा?
13 also,
30.
30.
Yes.
It is the case of the plaintiff.
Yes. Yes.
It is the case of the plaintiff by para 15 of the plaint that the pro forma defendant Thakri Devi, Kasi Poddar and Meena Devi, who are defendant number 2, 3 and 4 respectively, were in need of money and hence they sold their allotted 1 decimal land towards southern side to him by a registered deed of sale bearing sale deed number 493 dated 2010-2008. And after the said purchase, the plaintiff became the rightful owner of 1 decimal of land with a structure thereon. On the other hand, the contesting defendant Syamlal Poddar has pleaded in written statement that the pro forma defendants were never the owner of 1 decimal of land towards southern side and the alleged sale of that land of the plaintiff is malafide. The defendant Syamlal Poddar has also pleaded that the sale deed in question is a fictitious document prepared on 2010-2008 during the pendency of the proceeding under section 144 CRPC, which was not known to him since before he received copy of the plaint of the suit. It is also his case that the plaintiff has never become rightful owner of the suit land since the vendors themselves have no title over the same. The defendant number 1, Lilavati Devi, has similarly pleaded. Now, Lordship, in the course of trial, the deed of sale executed on 2010-2008 by Thakri Devi, Kasi Poddar and Meena Devi have been proved at Exhibit 1 without objection. Although the contesting defendants have challenged the execution of this deed in the course of trial, they have admitted at the time of their cross-examination and they have never challenged the same in any court of law, nor prayed for its cancellation. Besides, neither they have alleged that the heirs of Moti Poddar had got no title to the property sold by them, nor they have filed any counterclaim. In view of the above, the sale deed, proved by Exhibit 1 is found to be a valid piece of document showing transfer of the suit land in favor of the plaintiff and thus creating right, title and interest in his favor. Thus, this issue is decided in favor of the plaintiff and against the defendants. Now, Lordship, may kindly see issue number 2, which has been dealt with by the learned trial court in para 16.
Yes.
The contesting defendant Syamlal Poddar has taken the plea that suit is bad for non-joinder of necessary parties, as all the heirs of Narsingh Poddar, the original owner of the suit land, has not been made party. He has pleaded that Narsingh Poddar had 3 daughters, Amli Devi, Vomi Devi and Shanti Devi, but the plaintiff had deliberately omitted their names. The other contesting defendant, Lilavati Devi, has pleaded. Similarly, in para 4 of her written statement that all the heirs of Narsingh Poddar have not been made parties in the suit. Although the written statement filed by her does not mention the names of the heirs of Narsingh Poddar, in absence of whom the suit is bad for non-joint. On consideration of the pleadings of the parties and taking into consideration the facts of the suit, this court finds that Lilavati Devi has already been made party in the suit by order dated 10/11/2009, and the pleading of the defendant regarding non-joinder of few others, that is 3
How
daughters
is
of
Lilavati Devi, how is this finding coming? Lilavati, how is Lilavati related to Narsingh Poddar except that gifted it? Merely because Lilavati becomes a party, the plea of non-joinder of daughters, how can it be decided?
Lordship, non-joinder of the daughters of Narsingh Poddar.
Yes, who is Lilavati Devi?
Lilavati Devi, my lord, is wife of Syamlal Poddar.
Then how is it related? How the issue of non-joinder is related to Lilavati having been made part?
Lilavati, we have no manner of concern.
No, but issue number 3 को decide करने में तो यही बोल रहे हैं ना कि लीलावती पार्टी बन गई है तो बेटियों को पार्टी बनने का जरूरत नहीं है। ये कैसे हो?
तो ये finding perverse finding. This finding is perverse.
Lilavati
This is my
is
submission.
Lilavati is wife of
Shyamlal Poddar. And daughter-in-law of Narsingh Poddar.
that's right.
This is Milord the
So
point.
भाभी बन गई पार्टी तो नंदो को बनने का जरूरत नहीं।
जरूरत
यही है ना?
यही
अब appellate court में।
Appellate court.
But the fact remains that you never challenged the
Yes,
sale
yes,
deed.
that is there, Lord. That is there.
And the plaintiffs are claiming from the sale deed.
Yes.
And if that remains intact, the case of the plaintiff is foolproof. How are these issues important? Because it is not a case that she did not have any right over. At best, your case is that she sold her undivided share maximum.
Undivided share, Milord.
Maximum.
And Lordship, this is a document of partition.
You forget about the partition. When there is a sale deed standing on your way, you have never challenged it. It stands as it is.
But Milord, if sale deed is void, Milord.
It is not void. It is voidable. It is not void.
Sale deed has not been challenged.
Then,
I am not disputing the
Then-
legal proposition.
the sale deed having
Sale
not
deed
been
has not
challenged,
been challenged.
so
But
it
Milord-
remains intact.
But Milord, the doubters of Narsingh Poddar, they are necessary parties.
You see,
Because
therefore, in sale deed, had you challenged the sale deed, right? Then there would have been a question whether they are necessary party, what share do they have on it. But you have not challenged
But
the sale deed.
Lordship may kindly see Exhibit 4
We have seen exhibit
from
4.
where
I just want to know from you, even if both the issues are decided in your favor, then also how will it affect the sale deed?
then Milord,
Then how will it declare, how this court will declare the sale deed as void?
cannot be.
Cannot be.
By any stage of
So
imagination.
these questions are irrelevant.
But sale deed itself is void. Because Milord, the doubters of Narsingh Poddar,
It will not become void. Not at all.
on the basis of
Void.
Lordship, on the basis of the memorandum of partition, the pro forma defendants, Milord, they have sold the property to the plaintiff.
So,
If-
not on the basis. They are otherwise also the legal heirs and successors of that property.
This is not the finding, Lordship.
Need not be. The point is that this particular sale deed, the court has taken note of that this sale deed has not been challenged. Specific question were put to you that
Lordship,
it was
I am not disputing, Milord, the legal proposition. It has not been challenged.
Okay,
How
let
can-
us
how-
see
how-
the appellate court order.
How can I say, Milord, that it has been challenged?
Let us see the appellate court order.
My submission is, Milord, that suit is bad on account of non-joinder of necessary party. This is my submission. Now, Lordship may kindly see para 11.
Para 11 of the appellate court order.
Lordship.
Read the point for determination.
Whether the learned lower court has wrongly decided the issue that plaintiff has got right title and interest over the suit property without considering the fact of all the legal heirs of late Narsingh Poddar and the fact of alleged partition between Shyamlal Poddar and the legal heirs of Motilal Poddar. Whether the impugned judgment and decree of the learned trial court are justified and it calls for any interference.
You read para 12, buddy.
Both points are related with each other, hence they are taken jointly for discussion. I have produced the pleadings and evidences available on record and considered the submissions of learned counsel for the party. It is admitted fact that 2 decimals land from plot number 1206 and 1206/2305 of Moja Karma Town was purchased by one Narsingh Poddar, son of late Raghu Poddar of village Posta. It is also admitted fact that said Narsingh Poddar died in the year 1999, leaving behind the legal heirs of one son Motilal Poddar, who are pro forma defendants, and another son Syamlal Poddar, who is contesting defendant and appellant here. It appears that the case of the plaintiff, that the pro forma defendants who are the legal heirs of said Motilal Poddar were allotted the half share in the said purchased land of Narsingh Poddar, and they have sold 1 decimal of land to the plaintiff through registered sale deed dated 2010-2008. It is further case of the plaintiff that after the death of Narsingh Poddar, his son Syamlal Poddar and the legal heirs of another son, Motilal Poddar, succeeded the purchase portion, and the said land was amicably divided half and half by them in equal share, and 1 decimal of southern side land and a structure was allotted to the legal heirs of Moti Poddar. And in this respect, memorandum of partition was created on 2011-2005, which has been proved as Exhibit 4. Other case of the plaintiff is that the legal heirs of Moti Poddar are the pro forma defendants, and they have sold 1 decimal of land and a structure thereon allotted to them in southern side to the plaintiff through registered sale deed, and the said sale deed has not been challenged till date by the contesting defendant, and thus plaintiff has got right and title over the suit land. On the other hand, contesting defendant Syamlal Poddar has pleaded that the entire 2 decimals of land purchased by his father has been gifted to his wife Leelavati Devi by his father in the year 1995 through a notary affidavit, and he and his wife Leelavati Devi are in possession over the suit land, and his wife Leelavati Devi has perfected her title over the suit land by way of adverse possession also. He has further pleaded that the plaintiff has suppressed the fact by not including the 3 daughters of the said Narsingh Poddar, as the 2 sons of Narsingh Poddar exclusively never succeeded to the purchased portion of the land, and these 3 daughters were necessary parties, and these daughters were the legal heirs of Narsingh Poddar. But plaintiff has shown that the alleged plot was divided in equal share between the heirs of Motilal Poddar and Syamlal Poddar. Contesting defendants have pleaded that the alleged partition document is forged and spurious, and pro forma defendants have no right to sell 1 decimal land to the plaintiff, and the alleged sale deed does not confer title to the plaintiff, as the contesting defendants, who are husband and wife and the legal heirs of Narsingh Poddar, are in possession over the same, and the said contesting defendant Leelavati Devi has obtained the suit land by way of gift deed and has also perfected her title by way of adverse possession. In view of reading of both the sides and evidences, it is apparent that the plaintiff respondent has purchased 1 decimal land of the aforesaid plot number 1206 and 1206 of the 2305 of Moja Karma Town through registered sale deed Exhibit 1 from the legal heirs of Motilal Poddar, the son of Narsingh Poddar. The said legal heirs of Motilal Poddar have been made party as pro forma defendants, and they have also filed their witness statement in which they have admitted the execution of sale deed of the suit property in favor of the plaintiff, and they have not objected the claim of the plaintiff in their witness statement. The plaintiff and his witnesses have also proved the execution of the sale deed of the suit property in favor of the plaintiff. The plaintiff has brought a document as पारिवारिक आपसी मौखिक बंटवारा का निदेशान पत्र between the legal heirs of Moti Poddar and Shyam Poddar, which have been proved as Exhibit 4, although it does not bear the signature of a scribe, but PW11 Pradeep Mandal has stated that his father had written the said Matwara Patta Patra, and PW6 has also proved the creation of the said Patwara Patra. And even the contesting defendant Syam Lal Poddar, who has examined himself as BW3, has also admitted in para 31 that his paternal house is in village Kosta, and during the lifetime of Narsingh Podar, he and his brother Motilal got separated and the entire property were divided by his father in two equal shares. It further appears that contesting defendant Ramlal Podar has not challenged his signature over the alleged deed of partition. It further appears that contesting defendant Shyamlal Poddar and his wife have claimed the entire 2 decimals of land purchased by the said Narsingh Poddar on the basis of a gift deed alleged to be shown before notary. These contesting defendants Shyamlal Poddar has admitted in para 5 of the WS that the daughters of Narsingh Poddar, namely Amli Devi, died on 10/2008 and Bhumi Devi died on or about 2000, which shows that they were dead prior to filing of the suit. And these contesting defendants have nowhere stated that these doubters have ever claimed any right in the suit land. Rather, these defendants have claimed the said 2 decimals of land, including suit land, to be their own. The plaintiff has purchased 1 decimal land, and since the contesting defendants had obstructed in taking possession, he has filed the suit against contesting defendant for declaration of his right, title and recovery of possession. Certainly it is a declaratory suit and not a partition suit. And further it appears that doubters of said Narsingh Poddar or their heirs have never claimed any title, and even contesting defendants have examined D.W. who is the son of alleged daughter of Bhumi Devi, and in spite of having knowledge of on the basis of gift and by way of adverse possession, it appears that the contesting defendants have claimed the suit land on the basis of unregistered deed of gift alleged to be executed by Narsingh Poddar in the year 1995, and the said Leelavati Devi entered into possession and continued to reside there. But the said deed of gift, which has been marked as Exhibit A, is an unregistered instrument, and on perusal it appears that a stamp for this deed was purchased 2 months prior to its alleged creation on 7/12/1995. At the same time, it also cannot be denied that the said Narsingh Poddar was bedridden for the last 5 to 6 years, and he was not in a position to attend nature's call, and he died in the year 1998.
Yes, we have read it. आप भी घर पे पढ़ी होंगी. You just tell us one thing. Gift deed has been disbelieved by both the courts. There is no legal issue on that. No substantial question of law. The case of the defendant was based on the gift deed. They claimed that the property was gifted by Sada document in favor of the wife of one of the sons. Correct? So the entire claim was on the basis of gift deed, not on the basis that it is an undivided portion or there was no partition. That is not the case of the defendant. And this is over and above the fact the deed which was executed in favor of the plaintiff in the year 2008 was never challenged.
Lordship,
Even if there was a gift deed, the deed executed in the year 2008 ought to have been challenged.
Lordship, sale deed has not been challenged. It is an admitted fact. The sale deed executed by the legal heirs of Moti Poddar in favor of the plaintiff has not been challenged. But Lord, the specific case of the defendant in the written statement is that doubters of Narsingh Poddar, they are necessary parties.
To what?
Necessary parties in the suit, and in absence of in their absence, my lord,
Out of the 3 daughters, 2 had already expired.
their sons are alive, my lord.
We do not know.
They
From where do we get this?
Lordship, we have.
Their sons are alive. कहाँ से?
Lordship, I have stated in my written statement. Lordship, may kindly see.
Who were the sons?
They
who were alive?
There is a specific.
Who are the sons of those daughters who were alive? And one of them had deposed before the court, making no claim. And the point of law which has been formulated is not in connection with non-joinder of parties in the suit. It is in connection with non-joinder of daughters in the partition deed.
Partition.
Yes.
Yes.
So we are not concerned with non-joinder of parties in the suit. We are only concerned with non-joinder of, of daughters in the partition.
Lordship.
Yes. तो सूट में पार्टी है कि नहीं है वो तो इशू ही नहीं है हमारे पास.
फॉर्मुलेट तो इशू तो
आप पढ़िए फॉर्मुलेट जो पढ़ा
फॉर्मुलेट नहीं इशू जो
ट्रायल यही है. ट्रायल नंबर 6 पढ़िए ना, जो भाई आप ही के कहने पे ना मॉडिफाई हुआ है, आप ही का अपील है.
जी जी.
आप पढ़िए वेदर ओरल फैमिली पार्टीशन पैरा 6. भाई उनको कॉपी दीजिए ऑर्डर की 13/2/2025. अपलोड नहीं करते हैं क्या आप लोग? यस. ये कौन अपलोड किया है? कुणाल जी. और इसमें डेट नहीं है अपलोडिंग. ऐसा नहीं होना चाहिए. अपलोडेड है ऑर्डर, दीजिए उनको कॉपी दीजिए. आपका सिस्टम काम करता है, कंप्यूटर काम करता है आपका? उसमें निकालिए तो जरा ये ऑर्डर. आपको बोल रहे हैं अपने सिस्टम में इस ऑर्डर को निकालिए 13/2/2025. फोन पर नहीं, आपके कंप्यूटर सिस्टम. समीर जी वो खुलेगा ना? बताइए जी, किसी को भेजिए जरा. कहाँ है रीत जी? कहाँ है? वेयर इज ही? रीत जी कहाँ है?
यस लॉर्डशिप.
अरे
लॉर्डशिप में कहीं इसी तरह से
आपने खोला सिस्टम में खुला?
अभी ऑन करो.
Para 6 lordship. Whether oral family settlement exhibit 4 entered into between the sons with respect to the property acquired by their father during his lifetime without making doubters as party to the said deed is binding upon the parties, and whether the findings of the learned appellate court is perverse and against the mandate.
So whether these daughters were required to be made party in the partition deed, the so-called family arrangement, or not, is the issue framed.
Yes.
The issue is not framed whether they were necessary parties in the suit. इसलिए वो issue नहीं है. पहला issue है whether on account of non-registration whether it is otherwise valid. Second issue है कि वो जो partition है, even if it is a family arrangement for a moment and memorandum of family arrangement, but all the legal heirs are not party and therefore it is not.
Yes. यही तो हम हमारा समझ.
इसलिए non-joinder of necessary parties in the suit is not the issue. दो अलग बात है ना. Non-joinder of parties.
It has not been formulated, but my lord, issue has been decided. Issue has been decided by both the courts.
Yes, yes.
This is my submission. Issue has been decided. Issue has been framed, and both the issues.
ठीक है, सुन लिए. और कुछ citation देना चाहते
हाँ
हैं?
citation.
हाँ बताइए.
नहीं. 2018 volume 15 SCC page 130 paragraph 14 lordship.
है मेरे पास. आप इसको देखिए.
And lordship 2015 volume 16 SCC
2015 volume 16.
16 SCC page 787.
ये वाला दे दीजिए.
Paragraph 12.2.
Para
12.2
12.2.
Lordship. This is my submission.
That's it. पहले इनका सबमिशन लिखाते हैं उसके बाद Essay number 157 of 2019 heard the learned counsel appearing on behalf of the parties. This appeal has been filed challenging the judgment and decree dated 26 to 2019 within bracket decree signed on 6/3/2019 passed by learned district judge 1 Jamtara dismissing civil appeal number 14 of 2017 and confirming the judgment and decree dated 31/3/2017 within bracket decree signed on 11/4/2017 passed by learned civil judge within bracket senior division bracket close 1 Jamtara entitled suit number 9 of 2009. The learned counsel for the this appeal has been admitted for hearing and following two substantial question of law have been framed. Paragraph 13 to 2025 का order से पैरा 4 में एक substantial question of law है, एक पैरा 6 में substantial question of law. The learned counsel for the appellant has placed the exhibit 4 and has submitted that exhibit 4 is the family settlement as claimed by the plaintiff, and as per the exhibit 4 it is dated 2011-2005 and the same is between wife, son and daughter of late Murthy Poddar on one part and Shri Shyam Poddar on the other. He has submitted that Murthy Poddar and Shyam Poddar were the legal heirs, were the sons of Narsingh Poddar, in whose name the property was standing. He has further submitted that the said document on the face of it revealed that on 2011-2005 itself there was a settlement between both the parts, between the legal heirs of Murthy Poddar on one hand and Shyam Poddar on another, and the said document revealed that the document by itself is a document of partition and not a memorandum of partition. He has further submitted that in absence of registration, the partition deed and the so-called family settlement was compulsorily registrable and consequently the same would not have been admitted in evidence being an unregistered document. He has further submitted that in absence of, no, he has further submitted that on account of non-registration of the family settlement, which was essentially a deed of partition between the legal heirs of Moti Poddar and Shri Syam Poddar, having not been registered, the first substantial question of law is fit to be answered in favor of the appellant and against the respondents. He has further submitted that in the said partition, the daughters of Narsingh Poddar have not been made party, and therefore, on account of non-joinder of the daughters to the deed of partition, the second substantial question of law is also fit to be answered in favor of the appellant. He has further submitted that if these two issues are decided in favor of the appellant, then the natural consequence would be the sale deed executed by the legal heirs of Moti Poddar in favor of the plaintiff in the year 2008 would be null and void, and consequently the plaintiff could not have claimed any right, title, interest and possession with respect to the property. He has submitted that there was no need to separately challenge the said sale deed, and adverse inference has been drawn by the learned courts for not challenging the said sale deed. यही है आपका कहना टोटल, मतलब इसका consequence यही है. He has further referred to the impugned judgments and has submitted that the defendants were claiming the property by referring to a gift deed executed by Narsingh Poddar during his lifetime in favor of wife of Syam Poddar. But the said gift deed has been disbelieved by both the courts, and there is no substantial question of law in connection with this gift deed. But irrespective of the gift deed, Syam Poddar, the defendant number 1, was legal heir and successor of the property belonging to Narsingh Poddar, and the daughters having not been made party to the family arrangement or settlement. The case of the plaintiff based on the sale deed executed in 2008 by the legal heirs and successor of Moti Poddar is of no consequence. Right? He has relied upon the judgment passed by Honorable Supreme Court, reported in bracket 2015 bracket close 16 SCC 787. Para number कौन सा पता है? Para 12.2, which deals with the effect of non-registration of documents, section 49, and also the judgment reported in bracket 2018 bracket close 5 SCC 376. Para number नहीं, ये वाला नहीं, ये नहीं, एक ये वाला पैरा, सेकेंड वाला जजमेंट ये है 2018 ब्रैकेट क्लोज 15 SCC 130 पैरा नंबर 14. to submit that the document of partition was inadmissible in evidence and could be looked into for collateral purpose if it was a stamped document. यही है? हाँ बताइए respondent.
First of all, my lord, all the contention that has been raised would not have been raised without challenging the sale deed, my lord. The first and the exhibit 4, which heavy reliance has been placed. If it is seen from the very first line, वैवाहिक आपसी मौखिक बंटवारा का निर्धारण पत्र, means it has happened, my lord. There was a oral partition which has been jotted down later on, my lord. Top portion of exhibit 4, my lord. पारिवारिक आपसी मौखिक बंटवारा का निर्देश पत्र, my lord. And this has been clarified by the Honorable Supreme Court, my lord. In 1963, if my lord may kindly see the relevant portion, para 13 of this, my lord, this judgment, my lord. Para 13.
Yes. Buddy?
Yes. Family arrangement as such can be arrived at orally. Its terms may be recorded in writing as a memorandum what has been agreed between the parties. The memorandum need not be prepared for the purpose of being used as a document on which the future title of the parties be founded. It is usually prepared as a record of what has been agreed upon so that there be no hazy notions about it in the future. It is only when the parties reduce family arrangement in writing with the purpose of using that writing as a proof of what they had arranged and where the arrangement is brought about by the document as such, that document would require registration as it, then it would be a document of title declaring for future what rights in what properties the parties possess. The document exhibit 3 does not appear to be of such nature. It merely records the statement of 3 brothers made, each referring to others as brothers and referring to the properties as joint property. In fact, the appellate in the statement referred to respondent number 1 and 2 as 2 brothers and co-partners. And the last paragraph, we 3 brothers having agreed over the statement, having made our own statement in presence of punch called by us and signed and kept the copy each document as a proof of it. The document to serve the purpose of proof.
That's you see in this document exhibit 4 आज दिनांक 20/11/2005 को दोनों पक्षों के बीच एक समझौता हुआ जो निम्न प्रकार है.
But ऊपर में जो मौखिक बंटवारा, it is
मौखिक बंटवारा
means the oral thing has already been happened, my lord. Now it has been jotted down, my lord.
the वारिसाना पारिवारिक बाप क्या है?
पारिवारिक आपसी मौखिक बंटवारा का निर्देशन पत्र.
इसका क्या मतलब?
Nirdeshan means it is being jotted down. Nirdeshan means the guidelines. Now, Nirdeshan means guidelines, guideline, direction or guidelines being jotted down. So, Maukik, it has already happened.
The Maukik?
Parivarik, Maukik word may be similar, Maukik. So, if it is Maukik.
इसको नहीं देखें आज दिनांक 20/11/2005 को दोनों लोगों के बीच एक समझौता हुआ जो निम्न प्रकार है.
देखेंगे.
Then
also, my lord, without a registered sale deed which is registered in my name, I am not claiming that title through any other. It is not a partition suit, my lord. I am totally on one thing. A registered sale deed I have purchased is from a person who is not having a title, even taking the consideration that aspect, my lord. The person who is not, is it becomes void ab initio, my lord, without challenging the same, and that is the specific finding. And appellate court, my lord, in para 12 has dealt upon.
You can say firstly that this does not require registration firstly,
Yes,
according to your construction.
Yes.
And secondly, you can say irrespective of the finding,
Yes.
the decree cannot be set aside
Set aside.
because the sale deed has
Not
not
been
been
challenged.
यही आपका
Yes.
What do you have to say that the daughters have not been paid? Made party?
My lord, daughters, non-jointer, if it would have a suit of partition, my lord, then daughters would have been a necessary party to this said suit, my lord. It is not a suit of, it is a declaratory suit, my lord. So, my lord, the appellate court has specifically given this finding, my lord. In a declaratory suit where I am asking for a right title interest, the person who has not been, if it is a partition suit, daughters would have been, my lord. And coupled with the fact, my lord, that non-jointer part has been discussed because they have nowhere stated that who are the surviving legal heirs of the other daughters who have not been made, were still alive.
One of the sons
Yes, my lord.
was made a witness.
As a
He had not claimed it.
claim the property. And nobody
As a
has
witness.
whispered about the claim the right title of the
Did they say in the written statement that who are the daughters who were to be made party?
daughters they have said, but admittedly they have died. my lord.
When did they die?
In a written statement. Lord, I am reading, Lord. The suit is bad for non-joinder of necessary parties. All the heirs of nursing Poddar, the original owner of the suit land, has not been made party. Nursing Poddar has three daughters, Imli Devi, Bhumi Devi and Santi Devi. Imli Devi died on 1/10/2008, leaving five sons Amardeep, Raju, Tumtum, Ashok, Pappu and one daughter Munni Devi. Bhumi Devi died about 2000, leaving six sons Tarni, Dhananjay, Nandu, Mahesh, Panchanam and Kailas and one daughter Bin Devi. Santi Devi is still alive. The plaintiff has deliberately omitted their names and has furnished an incorrect genealogy in the paragraph 4 of the plaint. Besides that, above the actual present owner of the suit, land is Lilavati Devi, the wife of defendant number 1, which fact is fully known to the pro forma defendant. So, my lord, the learned trial court has stated that Lilavati, they are saying the suit land belongs to Lilavati Devi.
That was a specific case.
And that was the specific case because through registered without a sada gift deed that has been given, my lord.
The learned counsel for the respondent plaintiff has opposed the prayer, has submitted that on the face of the exhibit 4, it is relating to oral partition and the decision arrived thereto, and it is a recital of the oral partition which has already taken place, and therefore it was not compulsorily registered. Mr. Amit said both the courts have rightly referred to Exhibit 4. The learned counsel has further submitted that as per the written statement filed by the defendant who are the appellants before this court, their specific case was that the property was belonging to Lilavati Devi, wife of defendant number 1, and they claimed the property in favor of Lilavati Devi on the basis of a gift deed which was disbelieved by both the courts. And no substantial question of law in that connection has been framed, and therefore finding in connection with the gift deed has already become final. He has submitted that the plaintiff was claiming the property on the basis of registered sale deed of the year 2008, which was never challenged by Lilavati Devi or any of the defendants. And the defendants were claiming the property by stating that the property belongs to Lilavati Devi by virtue of gift deed. He has also submitted that the case of the defendant as set up in the written statement has been disbelieved. The learned counsel has submitted that the present suit is not a partition suit, so as to ensure that all the legal heirs and successors of Nursing Poddar were required to be made party, and the plaintiff had only claimed a declaratory suit on the basis of a registered sale deed which was executed by the legal heirs of Moti Poddar, who claimed to have exclusive possession on the over the property on the basis of oral partition recorded duly on 2011-2005, and otherwise also they had the right over the property. It cannot be said that the sale deed was null and void. Had the sale deed was challenged, then under such circumstances the legality and validity of Exhibit 4 was required to be examined, and under such circumstances the right of the daughters also could have been adjudicated upon. But in a case where the sale deed has not been challenged, there is no question of adjudication of the right of the daughters, and the sale deed by no stretch of imagination can be said to be void.
And one last matter, that residing from a family arrangement, the persons are stopped from residing from a family arrangement. The Honorable Supreme Court specifically has held in 2029 SCC 706. If somebody is residing from a family, he has been stopped. The principle of estoppel will come along.
The Learned Counsel has relied upon the judgment passed by the Honorable Supreme Court reported in AIR 1963 SCC Online 167 para 13 to submit that family arrangement can be arrived orally and its terms may be put in writing, and such a written instrument will not be compulsorily registrable under Section 17 of the Registration Act, and therefore the reliance on Exhibit 4 was not hit by Section 17, Section 49 of the Indian Registration.
On the same point, another judgment I am relying on.
काहे के लिए दो judgment क्यों चाहिए?
But here the case was similar, my lord. Only the party position is different, my lord. If the facts of this case are seen, my lord. Here the first appellate court
also relied upon a judgment passed by the Honorable Supreme Court reported in
2029 SCC
2020
9 SCC 706
706
para 17.
para 17, and has submitted that this judgment stands on similar facts as that of the facts involved in the present case, and therefore
There was a concurrent finding, then the High Court reversed that concurrent finding, then the Supreme Court, my lord, interfered.
ठीक है, इतना काफी खत्म. इसको असल में हमको टाइम नहीं मिल रहा लिखने को. स्वरूप ज़्यादा नहीं है इसमें. तो वो जो फाइंडिंग्स है लर्निंग ट्रायल कोर्ट का हम आपको बता देंगे अभी चलिए. इसको करिए, इसको सीए भी नहीं कर रहे, ठीक है, जितना जल्दी होगा कर लेंगे. सीए भी करेंगे इसको, देखिए इसको कर लेना है स्वरूप. ऑर्डर रिजर्व. एक चीज आपसे पूछ रहे हैं, in case where there is a family settlement and disbelieved, then also undivided share can be sold. Do you want to submit?
Yes, in undivided share, obviously.
Lordship, it is a settled principle of law.
The Learned Counsel for the respondents has also submitted that even if assuming though not admitting that the family arrangement was required to be compulsorily registered, then also considering the right of the vendor of the plaintiff, it was open to the vendor of the plaintiff to sell undivided portion of the property, even if it is assumed that there has been no partition. लिखा है कि नहीं लिखा?
No, it's not.
अच्छा ठीक
ये नहीं है।
ठीक चलिए छोड़ दीजिए
हाँ
इसको
इसको
हटा
छोड़ दिया है।
दीजिए। ठीक है लास्ट इसको हटा देंगे सॉरी
मतलब voidable का बात हुआ।
Void.
हाँ,
that would have come had that been challenged
yes मैम।
वो challenge होता तब आता
तब एकदम आता ये बात।
ठीक
काउंटर क्लेम अगर फाइल हो जाता तो एकदम इनका केस
हाँ।
थोड़ा कम अंदर तो
ठीक
Item 5 perspective 153 of 2023.
appellant where is the appellant
So I was praying Lord should may kindly be taken up next week because Mr. Amar Kumar should have been engaged and he has requested me to take a possible in this and for board meetings.
क्या करना है नेक्स्ट
सब रिक्वेस्ट किए थे जो आज टाइम के लिए तो नेक्स्ट वीक में दे दिया जाए हमारे पास
जॉइंट वेंचर में
नहीं नहीं हजूर हम बोले थे
हम
कि
तो नहीं दे रहे हैं उनको टाइम आप बहस करें प्लेन पड़ेगा
इसको नेक्स्ट वीक रख दिया जाए कि झालसा का मैटर है कुछ डॉक्यूमेंट नहीं है हम रिकॉर्ड नहीं कर सकते
झालसा का मैटर है तो और ज़्यादा आपको सीरियस रहना
हम सीरियस है जो पूरा चीज़ देख चुके हैं तो कुछ डॉक्यूमेंट हमको निकालना है जैसे
है FA number 153 of 2023 Learned Counsel for the appellant as well as the respondents pray for adjournment correct कब करना बताइए
77
बताइए डेट बताइए
17
आप भी बताइए
हम तो 10th के लिए 10th of March के लिए
छुट्टी के पहले नहीं हो सकता छुट्टी के बाद का डेट बताइए
18th को
At their prayer, this matter is adjourned and is directed to be posted on 18th of March 25 to be taken up at 2:15. It is made clear that no adjournment will be granted.
ओके
No further adjournment.
For hearing under order 41 rule 11 item 11 second bill 302 of 2016.
इसमें adjournment है ग्राउंड कुछ लिख के दिए SA number 302 of 2016. Nobody appears on behalf of the appellant. However, an adjournment request has been circulated by the counsel for the appellant, Mr. Neeraj Kishore, stating that he is suffering from fever and unable to attend the court proceedings. कोई आइए पेंडिंग है इसमें pose this case on 10th of June. Sorry, आपके हिसाब से डेट नहीं
Item 12, second appeal 325 of 2015.
Yes, applicant. Where is the applicant? क्या मैटर?
Lordship, partition suit है. They had filed a suit for partition, then that was reversed in first appeal, and then they have filed the second appeal.
What is the substantial question of law framed as per them? You are for the respondent. State. State.
No, Your Ladyship.
You have entered caveat.
We were issued notice in the matter of limitation.
Limitation has been condoned. Correct?
We could not ascertain from the orders that were available from the website.
Sorry.
Your Ladyship, perhaps we were appeared notices in the matter of limitation. From the orders, we could not ascertain whether it was in the matter of limitation. We'll check from the records. Because there are 4 orders which appear on our website of the Honorable Court. But
You were issued notice in which interlocutory application? You were issued notice by virtue of which order? By which order were you issued notice?
Your Ladyship, may I kindly verify this once?
वेरीफाई करना मेरा काम है
Your Ladyship, I'll verify वेबसाइट पर जो ऑर्डर्स है उसमें देखा नहीं.
और बाकी रिकॉर्ड आपके पास नहीं आपको मना कर देते हैं उन्होंने. Why did you say that it is for me to verify?
Your Ladyship, I will verify. I apologize for it.
ना बैठ के क्या कर रहे हैं सुबह से? क्या कर रहे हैं? आपको कोई ये लोग रिकॉर्ड देने को मना करते हैं?
I apologize. A supplementary affidavit was also filed by us informing about the death of one of the respondents earlier.
Who filed supplementary?
We had filed one supplementary affidavit in 2017 itself, Your Ladyship, informing about the death of
Respondent number 1
namely
who died in 2016.
Yes, Your Ladyship.
Respondent number 1 is the
Father of respondent was 2 to 4, defendant first party, then appellant, and then respondent.
case order essay number 325 of 2016. Nobody appears on behalf of the appellant. The learned counsel for the respondent is present. He submits that he has appeared pursuant to notice issued by the order dated 13th of April 2017. However, no substantial question of law has been framed so far in this second appeal. The learned counsel for the respondents has also referred to a supplementary affidavit filed in this case by the affidavit dated 28/6/2017. A copy of 17 stating that the respondent number 1 has already expired in the year 2016. The records of the case reveal that the matter has been running under the heading for Order 41, hearing on Order 41 Rule 11 CPC. And the following orders have been drawn from time to time. Order dated 11/1/23 करेंगे. उसके बाद ऑर्डर डेटेड 25/1/23 करेंगे, उसके बाद ऑर्डर डेटेड 1/3/23 करेंगे, उसके बाद ऑर्डर डेटेड 8/7/24 करेंगे, and when the case is taken up today, nobody is appearing on behalf of the appellant. The appellant has been given repeated opportunity, at times without imposing cost and at times upon imposition of cost. And today nobody is appearing. It seems that the appellant is not interested in pursuing this case. This appeal is dismissed for non-prosecution.
Item 13, second appeal 327 of 2016.
Yes, appellant.
Appellants were the plaintiffs. The suit land is pertaining to Jamabandi number 45.
Just a moment.
Jamabandi
Just a moment. Appellants were
the
plaintiffs.
plaintiffs.
Suit dismissed.
Suit dismissed and appeal also dismissed. First,
What was the suit for?
suit for partition. Partition of this lands of Jamabandi number 45 of village Belwa Ticket.
Jamabandi number 45.
45.
That is the property.
That is the property. 3 bigha, 10 kata and 8.
What is the reason for dismissal of the suit?
The suit is barred by law of limitation. And that
Partition suit.
that judgment which has been cited, my lord, is not at all applicable. That was a suit for correction of record of right. And correction of record of right, there is certainly limitation.
Partition suit में कौन सा limitation लगे?
कुछ भी नहीं होता है.
Can't find it. And appellate court has also returned the same
Yes,
finding.
same judgment has been cited by the trial court as well as the first appellate court.
कहाँ है दिखाइए? Limitation का वो point बना होगा?
Limitation का point बना है.
2 point दिखाइए. Unity of title and possession and law of limitation. ये दोनों दिखाइए. 4 and 5.
4 and 5. Four is whether there is unity of title and community of possession on the suit land, and whether the suit is barred by law of limitation. 4 and 5.
बताइए कहाँ है finding?
ये फाइंडिंग है अपीलेट कोर्ट का है पेज 38 में फाइंडिंग है.
नहीं, ट्रायल कोर्ट का finding.
राइट.
पहले यूनिटी ऑफ टाइटल एंड पोजीशन करिए.
ये पेज है 21 ट्रायल कोर्ट का.
हाँ देख लें. इशू देखें.
The plaintiffs have all
3, 4 and 5 जो है एक साथ डिसाइड किए हैं.
Yeah.
पैरा नंबर 7 में लिखे हैं.
हाँ.
करेक्ट. अब हमको दिखाइए यूनिटी ऑफ टाइटल एंड पोजीशन में क्या फाइंडिंग है.
ये कहते हैं कि हम 2 भाई थे, सुखोई एंड दुखोई. दुखोई के वंशज हम लोग और सुखोई के वंशज जो है सो डिफेंडेंट्स हैं. लैंड जो है सो रिकॉर्डेड है जमाबंदी नंबर 45 में in the name of both the brothers, but in remarks column possession of Sukhoi has been recorded. वो कहते हैं कि लाहौर बेटा था. ये एक बद्री कॉमन एंसेस्टर है दोनों का बाप. बद्री का फर्स्ट वाइफ से कहते हैं कि सुखोई का जन्म हुआ है और सेकंड वाइफ से वाइफ लाहौर लेके आई थी दिस
लाहौर क्या किसको बोलते हैं?
लाहौर मतलब ऑलरेडी फर्स्ट हस्बैंड से उसको बच्चा था, विडो से शादी किया। बच्चा के साथ आया, वो लाहौर हो गया। सेक्शन 50 ऑफ द एविडेंस एक्ट में है कि कब ओपिनियन ऑफ ए रिलेशनशिप विल बी सेक्शन 50 ऑफ द
Just-
एविडेंस।
पैरा 13 पढ़िए तो जजमेंट में।
From the aforesaid discussions of evidence of record, both oral and documentary, opinion and finding thereof, it is established that nothing could be brought contrary to the aforesaid statement of defendant witness, nor any material contradiction could be made, and whole statement of defendant witness fully standing, defendant witness fully stand, and the exhibits filed on behalf of defendants are the best piece of evidence, and so the claim of the plaintiff fully demolished. Rather, the defendants have fully established their case.
आप इंटरनल पेज 14 में आइए।
मैं इंटरव्यू में in this case I am not the respondent and respondent number 14 died due to appendix.
देखिए essay number 327 of 2016
नहीं पता,
counsel for the
नहीं पता है।
counsel for the appellant is present, the learned counsel for the respondent Mr.
Respondent number 6 and 14.
Respondent number 6 and 14 Mr. Manoj Kumar Shah submits that respondent number 14 has expired.
But
आपको कहाँ से information मिला?
today my lord I have got information.
कौन दिया आपको information?
One of the one Prakash Paswan.
तो आप legal heirs का नाम दे पाएंगे?
They
He submits that he shall seek instructions and provide the name of legal heirs and successors of
6 and
respondent number 14.
14 and 6.
दोनों मर गए
दोनों
भाई 14 and 6 दोनों मर गए ठीक है legal heirs and successors of respondent number 14 and 6 and 14 within a period of 15 days from today to the learned counsel for the appellant so that the appellant may take appropriate steps in the matter. He shall also provide a copy of the death certificate if issued so. Date of death भी देंगे ना साथ में. He shall also provide the date of death of respondent number 6 and 14. Post this case on April 8th and appropriate.
serial number 12 dismissed for non-prosecution. इसमें मेरे को इस appellant number 5 also died.
वो हम नहीं जानते अब तो dismiss for non prosecution हुई चलिए
Item 14, second appeal, 038 of 2016.
appellant तो या ये पेंडिंग है कैसे appears on behalf of the appellant. The records of the case reveal that in order dated 4/8/2022, it was reported that the respondent number 10 has expired. ये CMP 2011-2019 क्या है? Earlier, this appeal was dismissed for non-prosecution by the order dated 19/2/2019 and was restored by the order dated 6/12/2019, passed in CAP number 211 of 2019. After restoration, the matter was taken up on 11/1/2023. On this date, the appellant had prayed for time which was allowed as last chance. Thereafter, the case was taken up on 28/3/2023 and appellant again prayed for time which was allowed subject to deposit of ₹1,000 as cost. And today, when the case is called out, nobody is appearing on behalf of the appellant. It seems that the appellant is not interested in pursuing this case. Accordingly, this appeal is dismissed for non-prosecution. जितना भी केस में डेट हुआ है कॉस्ट करके सब केस आज हम डिसमिस कर देंगे. Those who are not appealing. रेस्टोर कराते कराते जो है ना 5 साल बीत जाए. इसमें एक डेड भी हो गया. कॉल करिए.
Item 15, second appeal 345 of 2016.
Yes.
So in this case, notices were issued to the respondent by order 16/4/2019 on the issue of limitation as well as appeal, Your Lordship. And we have filed the Vakatnam on behalf of respondent number 1 and 2, and the IE was allowed, Your Lordship. There was a delay of 25 days, and there is a concurrent finding in this case, and we are for the defendant, Your Lordship. substantial question of law is not framed.
Yes.
Lordship,
Yes. What is the substantial question of law in law? You are for the tenant or the landlord?
Lordship, we are claiming that the property, the plot number 703,
Title eviction suit.
eviction.
आप कौन है? टेनेंट है कि लैंडलॉर्ड?
हम लैंडलॉर्ड हैं, हम क्लेम कर रहे हैं इनहेरिटेंस से, और एक क्लेम कर रहे हैं कि वो ने गिफ्ट के रूप में मुझे एक प्लॉट दिया था 698, वेस्टर्न पार्ट ऑफ द 698, 3 कट ऑफ लैंड पे हम 1958 में वो
ओरल गिफ्ट
अनरजिस्टर्ड डीड।
आपको कभी रेंट दिए? रेंट दिए हैं आपको कभी?
नहीं, हम ही ये बोल रहे हैं कि हम इनके टेनेंट।
प्लेंटिफ कौन है?
प्लेंटिफ अपीलेंट, हम डिफेंडेंट।
They have filed the eviction suit.
एविक्शन सूट डिक्लेयरिंग कि हम फॉल्स डीड के थ्रू से।
Is there any document regarding tenancy?
No exhibited
Any
document.
document regarding payment of rent? Any oral evidence regarding payment of rent?
पेमेंट का नहीं है, ओरल एविडेंस ही लाए थे, तो बोल रहे हैं कि इनके रूप में, इनके यहाँ लेबर के रूप में काम करते थे और इनके यहाँ टेनेंट के रूप में रहते थे।
हाँ बताइए क्या है आपका सबस्टेंशियल क्वेश्चन?
Your Lordship, praying for a short pass over, Your Lordship, arguing counsel is on its way. And let this matter be heard in second.
केस कॉल आउट होने पे घर से चलते क्या? अभी तक ऑन इज वे?
Due to the emergency, Your Lordship.
आपका इमरजेंसी कब से चल रहा है? 1000 रुपये कॉस्ट हो गया, 2000 रुपये कॉस्ट हो गया, बताइए। ऐसे इमरजेंसी चलते रहता है आपका? इतना कैजुअली पेइंग फॉर टाइम। सेकेंड हाफ में आइए, नहीं तो एडजर्न करेंगे, 10,000 रुपये कॉस्ट होगा, ठीक है?